Good morning, Judge.
Good morning. Can you hear me all right?
Yes, Your Honor.
Yes, Judge.
All right, we will begin in Osceola County with James
From there.
Adrian, two cases, case number 2020 CF 402 and 2020 CF 394. Good morning. Are you Mr. Adrian James? Or, I'm sorry, James Adrian?
Yes, sir.
All right, Mr. Adrian, you're here for a first appearance on charges in two cases. First case, 2020 CF 402, burglary and grand theft, as well as 2020 CF 394, burglary and petty theft. You have the right to remain silent. Anything you say can be used against you. You do have the right to communicate with your family and with counsel. You have the right to counsel. And do you have the means to hire an attorney to represent you in these cases?
Yes. Your Honor, he qualifies, you're seeing him on behalf of the PD's office. He does qualify for appointment by the PD's office.
He does. Do you wish me to appoint the public defender to represent you in this matter?
You want us appointed? PD's office appointed? You want public defender's office appointed to your case? Yes, yes.
Yes.
All right, the court will appoint the public defender. Probable cause has previously been found with respect to all the charges. Does anyone wish to be heard as to bond?
No, Your Honor.
All right.
Your Honor,
Yes.
Dane Simpkins for the state of Florida. The state would leave the bond amount in Your Honor's own discretion.
Great. Bond previously set on burglary at 5,000, petty theft at 500, and burglary at 5,000 and grand theft at 1,000. Court will leave those bond amounts in place. And only condition of bond is no return to the location of the offenses. Anything else?
Judges, this is Jennifer Dunkirk from pretrial release. Is this on both cases, the no return?
Yes, both cases. I think they were both, oh no, they were different locations, correct? Two different McDonald's?
I'm not quite sure, Judge. If you want to stipulate on as to both cases, we
Your Honor,
can.
there are two different McDonald's.
All right, no return to either, please. Anything further?
Thank you, Judge.
No, Your Honor.
Nothing from the state.
All right, thank you.
Hold on.
Next case is Idris Ben Hakoum. Good morning, sir. Are you Mr. Ben Hakoum?
Yes, sir.
All right. You are here for an initial appearance on charges of violation of a domestic injunction. You have the right to talk with your family and friends regarding this matter, as well as the right to appointment of counsel. Do you wish to have the public defender appointed for you in this matter?
So yes.
Yes, ma'am. Yes, sir.
And the court finds probable cause for the alleged violation of the domestic violence injunction.
But I believe, I think that,
Judge, Officer Dunkirk with pretrial release, we actually reached out to the victim, and she states that she does want contact.
She's not present. Did she indicate why she wouldn't be here, or is she present there?
No, Judge, we spoke to her over the telephone from the number that the arresting officer provided. Also, the defendant has previous injunctions that has been dismissed. He does not have any convictions whatsoever.
My concern is in the charging affidavit, allegations with respect to alleged schizophrenia and threats of suicide. Is mental health pretrial release available in this case?
Due to the 907, Judge, it requires bond, but we can also add PTR with mental health conditions on that, Judge.
State like to be heard on bond?
Your Honor, the state would request that there be some sort of mental health treatment or mental health PTR attached to this. In light of the wishes of the victim, no contact order is not necessary. However, the state would also request no hostile contact if Your Honor is inclined to release the defendant. And furthermore, Your Honor, the state would note in terms of determining bond and whether to set it, and if so, in what amount, that at least according to the information provided in the charging affidavit to the state, the victim at the time did indicate that she was in fear for her life due to the actions of the defendant, and the state would ask that the court take that into consideration when determining how to proceed.
All right, the court will set bond in the amount of $500, order mental health PTR, and no hostile contact.
Judge, can we have mental health with PTR with mental health conditions? It's a different requirement, but essentially it's the same.
If it's the same but different, that works for me.
One requires a diagnosis and one does not.
Which one is which?
A direct mental health pretrial release attached to any monetary bond requires that we verify his diagnosis, whereas PTR with mental health conditions does not, although the conditions of release is the same.
All right, court will order PTR with mental health conditions.
Thank you, Judge.
Thank you. Anything
Yes.
further?
Nothing from the state,
Thank
Judge.
you,
Your
sir.
Honor. Bobby Cox.
Next case is Bobby Cox.
Judge, we also spoke to the victim in Ms. Cox's case as well, and he requested no hostile contact. Ms. Cox also has no criminal history whatsoever.
Also, Judge, she does qualify for and does want the appointment of the PD's office.
Qualifies for and does want?
Yes.
Okay.
Does want. She does want the appointment.
All right, Ms. Cox, you are here on a charge of simple battery. Court has reviewed the charging affidavit and finds probable cause for the offense alleged. And based on what counsel's told me, will appoint the public defender to represent you. Does the victim reside with Ms. Cox?
No, no.
No, Your Honor. She indicates that the victim does not reside with her.
All right. State have any input as to bond?
Your Honor, the state would leave it in the court's discretion, but the state would like to indicate that in the charging affidavit, the victim at the scene of the crime, in fact, presented with multiple lacerations on his face, including traces of blood. It's the state's position that this was a rather serious offense, and the state merely requests that the court take it seriously when determining how exactly to proceed with the case.
Can you tell me a little bit more about the victim's request for no hostile contact? Was there a specific request for contact?
When I spoke to the victim judge, he just indicated that he is not in fear of his life and that he requests the no hostile contact. I specifically told him what the difference was between the two, and he requested the no hostile contact. He also advised that he did not reside with Ms. Cox.
All right. Court sets bond at $500 and will order no hostile contact with the victim.
Judge, is that with pretrial release or no?
Does she want it?
Is that with pretrial release?
Is she requesting it?
Your Honor, we asked, Your Honor, we asked Yasina on behalf of Ms. Cox. We request that PTR not be applied, just the $500 bond by itself.
All right. Just the monetary bond, then no PTR.
And the state would request PTR.
Thank you, Judge.
In the event of a release.
Good.
All right. Thank you. This is the matter of Raymond Diaz. I understand this is a violation of probation. Mr. Diaz,
That's
is that you?
correct.
Yes, sir.
All right, you have the right to remain silent. You are here for first appearance on this violation of probation charge. You've got the right to remain silent. Anything you say can be used against you. You do have the right to counsel. If you cannot afford counsel, the court will appoint the public defender to represent you. Do you wish for the public defender to represent you?
Yes, sir.
All right, court appoints the public defender to represent Mr. Diaz. This is a violation of probation. Does anyone wish to be heard?
Yes, Your Honor. At this time, we ask Your Honor to set a reasonable bond on the case.
Your Honor, Dane Simpkins for the state. On my sheet, it appears to be a violation of community control specifically. Is that correct?
That's what I'm seeing.
Your Honor, considering the fact that community control is already a very severe form of trying to attempt to make sure that somebody follows the conditions that are imposed upon them by the court system, the state would request that the defendant not be entitled to bond at this point because of the fact that he has, in fact, violated that community control. The state would point out that because of the fact that this is a violation of probation warrant specifically, it's the opinion of the state with regards to State versus Norris, 737 Southern 2nd, 1240, and Mata versus Lamberti, 993 Southern 2nd, 642, that the bond cannot be adjusted at this time. The appropriate relief for the defendant in the state's position would be to address this with the trial judge, and the counsel would be able to do so at a later opportunity.
All right, thank you very much. Defendant will be held without bond until further hearing in the underlying case in the trial division. All right, thank you. Right, Jamie Dominguez, is that you, sir?
Yes, sir.
All right, you're here for a first appearance on charges related to burglary, grand theft, and criminal mischief. You have the right to remain silent. Anything you say can be used against you. You have the right to communicate with friends and family, and we can make accommodations for that purpose if you need to. You have the right to an attorney, and if you can't afford one, the public defender can be appointed for you. Do you wish for the court to appoint the public defender to represent you?
Yes, sir.
All right. Probable cause was previously found with respect to all claims. Are these new charges? State,
Your Honor, I believe these are just the original charges.
I'm sorry? They're the original
I believe
charges?
these are just the, yeah. It's the warrant.
All right, anything from the state?
No, Your Honor.
From the defense?
Yes, Your Honor, just to keep bond as currently set.
Court will keep bond as currently set in the amount of $2,000 on the burglary charge, $500 on the grand theft charge, and criminal mischief, $1,000. Anything further?
Nothing from the state.
Nothing from the defense.
All right, thank you, sir.
All right, thank you.
All right, Pierre Evans? You, Mr. Evans, sir?
Yes, sir.
All right, good morning. We're here for an initial appearance on a charge of trespass after a warning. You have the right to remain silent. Anything you say can be used against you. You've got the right to communicate with friends and family, and we can make accommodations for that if you need to. Do you have the ability to afford a lawyer, sir?
No, sir.
All right, do you wish the court to appoint the public defender to represent you?
Yes, sir.
All right, court finds probable cause for the charge alleged. State, any input?
The state would just request that the bond be kept as is.
Defense?
Agreed, Your Honor.
Judge, Officer Dunkirk from pretrial release, Mr. Evans actually qualifies for direct pretrial release. Would you be inclined for a non-monetary bond?
PTR.
Does the defense request it?
Yes, Your Honor. He does want PTR over
State.
the $500 bond.
Your Honor, the state would simply point the court to the fact that the charge alleged is a trespass after warning. These are generally offenses in which someone is persistently returning to the same location, though, of course, the state doesn't have any information to indicate, for instance, that it was actually a burglary or something like that. The state would urge the court to keep in mind that this is not the first time that the defendant has gone to that location and apparently is not to be welcome there. The state would request the $500 bond, would also request that the defendant be ordered not to return to that location.
Court will order PTR with the condition of no return.
Thank you, Judge.
Thank you.
You can have a seat. Yes, sir.
All right, Geraldo Arias Nunez, is that you, sir?
Yes, sir.
All right, good morning. You're here for an initial appearance on a charge related to knowingly driving with a suspended driver's license. You have the right to remain silent. Anything you say can be used against you. You have the right to communicate with friends and family, and we can make accommodations to assist you in doing so. You have the right to an attorney. Do you have the ability to afford an attorney?
No, sir.
All right, do you wish the public defender to represent you in this matter?
Yes, sir.
All right, court appoints the public defender. Court finds probable cause for the offense alleged. Does anyone wish to be heard?
State leaves it in
Judge.
your Honor's discretion.
Yes.
Judge, Officer Dunkirk, pretrial release. Mr. Nunez actually meets the criteria for pretrial release. Would you be inclined to release him on a non-monetary bond?
Your Honor, he'll prefer to be, to bond out on the $500 as opposed to PTR.
All right. Court sets bond at $500. All right, thank you very much. All right, Mr. Keel?
Good morning.
Good morning. You are here for an initial appearance related to an out-of-county warrant. You have the right to remain silent. Anything you say can be used against you. You have the right to communicate with your friends or family to the degree you need to. You also have the right to an attorney. Do you have the ability to afford an attorney?
Yes, sir.
Do you want the court to appoint the public defender to represent you?
Your Honor, he wishes to hire a private attorney at this time, and he's also out of county, so you won't be able to, I think, appoint him.
You're right, I didn't realize that. All right. Mr. Keel will be held pending further proceedings in the underlying case in the jurisdiction where he was charged. Anything further?
No, Judge.
No, Your Honor.
All right, thank you. Linda Manning?
Yes, yes, sir.
All right, you're here this morning on an initial appearance related to an out-of-county warrant for violation of probation. Anyone wish to be heard on this case?
Yes, Judge. Dane Simpkins for the state of Florida. I would just reiterate what I had noted previously with regards to the state of the law in those two cases that indicate that because of the fact that this is a violation of probation warrant, especially one for the violation of community control, the initial appearance judge is not able to modify that bond, but rather, at a later point, defense counsel should file the appropriate motions in order to try to set bond.
All right. Ms. Bennett, can you
Defense, Your
report?
Honor.
I'm sorry?
Nothing from the defense in respect to what the state just said.
All right, if there's nothing further, Ms. Manning will be held without bond pending further proceedings in the underlying case. Thank you.
Hello.
Good morning, Carmen McLean?
No, I'm Stephanie.
She bonded, Judge.
She did.
Yes, Judge. This is Stephanie McKee.
All right, great. Hello, Ms. McKee.
Hello.
Here this morning for an initial appearance on a charge of driving with a suspended license. You have the right to remain silent. Anything you say can be used against you. You have the right to communicate with friends and family if you need to, and we can make accommodations for that. Do you have the ability or the resources to hire an attorney to represent you in this matter?
No, I don't.
All right. Court will appoint the public defender to represent Ms. McKee.
And Your Honor, Ms. McKee doesn't have any history, if I'm not mistaken. We'll ask that she be released on ROR. It is a driving without a license charge.
The court finds probable cause for the charge for the purposes of the record. What says the state?
State leaves it in Your Honor's discretion.
Judge, Ms. McKee actually meets the criteria for pretrial release. She only has one prior battery, which was dropped, and that was in 2018. She has no convictions.
The court were inclined to consider a monetary bond, would your client prefer PTR or a monetary bond?
PTR.
She prefers PTR, Your Honor.
All right. Court orders PTR.
Okay, thank you.
Thank you.
Okay, thank you.
John Tavius Myrtilus.
Hey, how you doing?
Hello, sir. Here for an initial appearance related to an active warrant out of Hillsborough County. Does anyone wish to be heard on this case?
Your Honor, Dane Simpkins for the state. The state would simply request that the defendant be held in order to be able to bring the defendant to Hillsborough County. From what the state sees, the Hillsborough case does have a CF case number, meaning that this was a felony. Considering the fact that it may be a rather serious offense, the state doesn't recall what specific offense the warrant was
Aggravated
issued.
battery.
Aggravated battery. Because of the seriousness of the offense, the state would request that the judge keep the defendant in custody so he can be transported.
Nothing with defense, Your Honor.
All right. Defendant will be held pending transport to Hillsborough County for further proceedings.
You're good.
Elisa Perlet? Is that you,
Yes, Your
ma'am?
Honor.
Hello, how are you?
Great.
We're here for initial appearance on charges of simple battery in the first degree misdemeanor. You have the right to remain silent. Anything you say can be used against you. You have the right to communicate with family regarding this matter or friends, and we can make accommodations to you if you need to do so. You have the right to counsel, and the court can appoint counsel for you if you don't have the means or the ability to afford it. Do you wish the court to appoint the public defender to represent you in this matter?
Yes.
All right, court appoints the public defender, finds probable cause based on the charging affidavit for the offenses alleged. I understand the victim has requested contact.
Yes, Judge.
Sorry.
I spoke to the victim this morning, and he requests no hostile contact for her to return home. They're also business partners as well.
State?
Your Honor, state would recommend a pretrial release with the added condition that there be no hostile contact with the victim.
Anything from the defense?
Judge, due to the 907, it requires a monetary bond with pretrial release, if you wish.
Your Honor, we request that you set a $500 bond with no hostile contact condition.
Without PTR?
Without PTR.
Your Honor, state would suggest that pretrial release would offer another sort of layer of protection for the victim should the event ever occur.
Thank you, Judge.
All right, court will set bond at $500 and order no hostile contact.
Judge, so we're clear, without pretrial release?
That's correct.
Thank you.
Your Honor, the next individual on the list, Luis Ramirez Lamort, he's got to be reset for tomorrow. He's currently in detox.
All right, thank you. Juan Rios Garcia?
Your Honor, he will require the services of a Spanish interpreter.
All right.
We should have one on standby.
Madam Interpreter,
Your
are you
the
there?
Spanish interpreter is on the line.
All right, she's already taken the oath before and everything?
No, Your Honor, I have not.
All right. Please.
Do you swear to interpret from Spanish to English and English to Spanish the testimonies you will receive today?
I do, to the best of my ability. Flavia Rodriguez, State Certified Court Interpreter.
All right, thank you, ma'am. Mr. Garcia Rios, is that you?
Señor García Ríos, ¿es usted?
Sí.
Yes.
You are here for a first appearance on a charge of counterfeit license plate, a felony in the third degree.
Usted se encuentra aquí para su vista de primera instancia por una acusación de llevar matrícula de contrabando, un delito de tercer grado.
You have the right to remain silent.
Usted tiene el derecho a permanecer en silencio
And you have the right to an attorney, and if you cannot afford one, the court can appoint one to represent you.
y usted tiene el derecho a que le represente un abogado. Si no se lo pudiera costear, el tribunal le designaría uno para que le represente.
Do you wish
He
to
does
have the-
like to be appointed, Your Honor.
I'm sorry?
He does wish to have a PD appointed.
All right. Court appoints the public defender to represent Mr. Rios Garcia. I've reviewed the charging affidavit and find probable cause.
El acusado desea que se le designe defensor público. Bien, se designará defensor público para que represente al señor Ríos García. He leído el affidavit acusatorio y determino que existe indicio de criminalidad.
He qualifies for PTR.
Yes, Judge, he also has no criminal history as well.
Your Honor,
reúne
given
los
that this is a
requisitos para la
possession
libertad
Let him- let him-
Él reúne los requisitos para la libertad provisional, sí, su señoría, y además él no tiene antecedentes penales.
And I think the state has something to add.
The state has no objection, Judge.
Sin objeción de la fiscalía.
Right. Court orders PTR, no monetary bond.
Thank
Bien,
you,
se
Judge.
ordena el programa de la libertad provisional y no tendrá que pagar fianza. Gracias, su señoría.
Thank you.
Your Honor, Mr. Jose Rivera Cruz is up next, and he also requires the services of a Spanish interpreter.
Hello, Mr. Cruz, Rivera Cruz.
Hola, señor Cruz. Rivera Cruz. Good morning. Good morning.
You're here for first appearance related to a violation of probation.
Usted se encuentra acá para su vista de primera instancia por un incumplimiento con la libertad vigilada.
You have the right to remain silent, and anything you say may be used against you.
Tiene derecho a permanecer en silencio, ya que cualquier cosa que diga podría usarse en su contra.
You have the right to an attorney, and if you cannot afford one, the court can appoint an attorney to represent you. Do you wish for the court to appoint the public defender to represent you?
Usted tiene el derecho a que le represente un abogado. Si no pudiera costearse uno privado, tiene el derecho a que el tribunal le designe uno. ¿Desea usted que el tribunal le designe al defensor público para que le represente?
Sí.
Yes.
Court appoints the public defender. What says the state with respect to the bond? This is violation of probation, but a bond has been set on that?
Yes, Your Honor. Because of the status of the case law, that means that the bond should remain set exactly where it is.
All right. Bond set at 2,000. Anything further?
No, Judge.
No, Your Honor.
Thank you.
Se designa el defensor público. ¿Qué dice la Fiscalía con respecto a la fianza? Aunque es un caso de incumplimiento con la libertad vigilada, se había fijado fianza anteriormente. La Fiscalía plantea que, según lo que dice la jurisdicción, la fianza deberá permanecer tal y como estaba. Por tanto, la fianza permanece en cantidad de $2,000. Si no tienen nada más que agregar, muchas gracias.
Your Honor, the next individual on the list is Carlos Santana Brito, and he's refused to come today, so reset him to tomorrow.
You want to wait to the end? Are we on record? Are we in record?
Yeah, I'm just
Yeah, we should be.
thinking.
Yeah. Yeah.
All right, we'll reset him for tomorrow.
Yes, Your Honor. And then the next individual after that, John Segrist. He's in the back. We could address him at the very end.
Taylor. Taylor.
Taylor at the end. So next,
The next case that I have is Christian Smith. Hello, Mr. Smith. Here for an initial appearance related to an out-of-county warrant relating to underlying charges of fraudulent use of a credit card and extortion. You have the right to remain silent. Anything you say could be used against you. You have the right to an attorney. Do you wish for me to appoint the public defender to represent you?
Yes, Your Honor.
All right, court appoints the public defender. It's an out-of-county warrant. Does anyone wish to be heard?
Yes, Your Honor. The
No, Your
state
Honor.
would request that the defendant be held without bond in order to be transferred out of county in response to that warrant. Considering the fact that this was a victim offense that also includes rather serious offenses, and the current bond amount is set to zero, the state asks that the bond remain at zero.
All right. Defendant will be held without bond for transport to the jurisdiction of the underlying offenses. Thank you.
Christopher Sullivan?
Next case I have is Christopher Sullivan.
Yes, sir.
All right, sir, you're here for a first appearance on active warrant related to a failure to appear related to trespass. You have the right to remain silent. Anything you say can be used against you. You have the right to an attorney, and if you cannot afford one, the court will appoint one to represent you. Do you wish for the public defender to represent you in this matter?
Yes, sir.
All right, the court appoints the public defender to represent Mr. Sullivan. What says the state with respect to bond?
Your Honor, the cases cited previously by the state that apply to violation of probation also apply to failure to appear. It's my understanding that those two are both motivated by the same principal objective of ensuring that the trial court actually gets the defendant back and is able to address them directly.
All right, anything from the defense?
Yes, Your Honor. It appears that the bond's been set at $2,000. We ask that, Your Honor, given the fact that this was a trespass,
Yes, sir.
keep the bond either at the bond at the current amount set.
All right, court keeps bond at $2,000. Thank you very much.
You're good.
Thank you, sir.
Next case I have is Joni Thrasher Hopkins. Are you Joni Thrasher Hopkins?
Yes.
All right,
Yes.
we're here for a first appearance related to a violation of probation on underlying charge of DUI. You have the right to remain silent. Anything you say can be used against you, and if you can't afford an attorney, the court can appoint one to represent you. Do you want the court to appoint the public defender to represent you, Mr. Thrasher Hopkins?
Yes.
All right, court appoints the public defender. This is probation violation. Does anyone wish to be heard?
Yes, Your Honor.
Nothing from defense.
Again, Your Honor, as usual, the state requests that the court follow the previous cases cited and keep the bond exactly where it is in the amount of $0.
All right. Defendant will be held without bond pending further hearings in the underlying case for which the probation violation occurred. Thank you very much. Next case I have is Victor Valentin Fuentes. Good afternoon, sir. You're here for an initial appearance related to a charge of child abuse, assault, and battery. You have the right to remain silent. Anything you say can be used against you. You also have the right to an attorney, and if you can't afford one, the court will appoint one to represent you. Do you wish for the public defender to represent you in this matter?
Yes.
All right, the court appoints the public defender. I've reviewed the charging affidavit, and the court finds probable cause with respect to the charge. State wish to be heard as to bond.
Yes, Your Honor. The bond is currently set at no bond. The state requests that the court keep it at no bond. In this particular instance, Your Honor, the state would point out the grievousness of the offense, the fact that a child naturally has less ability to insulate him or herself from the defendant, to protect themselves, and to attempt to not suffer further harm, meaning that if the defendant is released, the child would be placed back into harm. The state would also note that Florida Constitution, Article 1, Section 14 notes that if no conditions of release can reasonably protect the community from risk of physical harms to persons, which the victim would count as, assure the presence of the accused at trial, or assure the integrity of the judicial process, the accused may be detained.
What says the
If I may,
defense?
Your Honor, yes, Your Honor. The victim in this case is his 14-year-old daughter. The allegations are that he came home and saw her with her boyfriend, and the incident occurred after that. I don't think there were any major injuries to the victim. I think bond should be set at an appropriate amount, and that he not go back to that house where she stays at, and that should take care of any sort of risks that may appear to the victim.
Well, tell me about that.
Judge, I'm sorry.
Go ahead.
The victim, we spoke with the victim's mother, and she's requesting no contact be put in place. Also, she will be filing an injunction.
Does Victor reside at that location presently?
Your Honor, he indicates that she was residing with him, but it appears now that she's with her mother.
Okay. So he has a place, if he bonds out, he has a place that he can return to where neither mother nor daughter are there?
That's correct, Your Honor.
Okay. Court sets bond in the amount of $5,000, orders no contact with the victim or her mother, and no return to the place of residence of the victim or her mother. And the no contact includes direct or indirect contact.
Your Honor, just so the record's clear, can we have it that he doesn't go to the location where the victim and the mother live? He will be returning to where it occurred, which is where he lives.
Oh, I'm sorry. Yeah, I
So instead of a no
misunderstood.
return,
Yeah, no return.
Or
Let's just say maintain separate residence.
that completely works. You're good.
Thank you, Madam Clerk. All right, thank you. I have Mr. Quick next. Is he present?
Yes, sir.
Hello, sir.
Hello.
Here for an initial appearance on charges against you for marijuana possession and drug equipment possession. This case was reset for today after a refusal to appear. You have the right to remain silent. Anything you say can be used against you. You also have the right to an attorney. If you don't have the ability to hire an attorney, the court can appoint one for you. Do you wish for the court to appoint the public defender to represent you in this matter?
Yes, sir.
All right, the court appoints the public defender and finds probable cause for the offenses alleged. Does anyone wish to be?
Judge,
Go ahead.
I'm sorry, Judge, pretrial release. Judge, Mr. Quick actually qualifies for a direct, non-monetary release through the pretrial release.
All right, I don't have a pretrial release form here.
This was a reset since since yesterday, from yesterday, rather, Judge.
Counsel,
And he would,
do you want to confer with your client?
he
as
would,
to-
pref-
Go ahead.
that's correct. He would prefer PTR over the $750 bond that's currently set.
All right. Court will order PTR Unless the state has anything to add, the court will order PTR with no monetary bond.
Your Honor, I don't know exactly how it would work in interfacing with the PTR folks, but the state would request either random alcohol or drug testing at defendant's expense or in order not to consume any alcohol or controlled substances.
Defendant, any objection?
No, Your Honor.
No, sir.
All right, no controlled substances or alcohol.
So Judge, just for clarification, the conditions of the release is no alcohol, no drugs. Was there any drug testing stipulated or no?
I'm not ordering that, but there is an element to verifying no controlled substances or alcohol as part of PTR, right? Even if it's not specifically ordered?
No, Judge. If you don't order no alcohol or no drugs, just the basic regular check-in would be ordered.
All right, court will order additionally random drug testing. Thank you.
Good.
I have another reset on Santiago Martinez Calderon. Hello, Mr. Martinez Calderon.
Hello.
You're here for an initial appearance related to an active warrant. You have the right to remain silent. Anything you say can be used against you. You have the right to counsel as well, and if you cannot afford counsel, the court will appoint the public defender to represent you. Do you wish for the public defender to represent you in this matter?
Yes, sir.
All right. Court appoints the public defender. Does anyone wish to be heard?
Yes, Your Honor, to keep bond, state bond as currently set.
State?
More than,
Your Honor, the state would leave the determination of the bond amount in Your Honor's discretion. I believe that the current bond as set should be the floor rather than the ceiling of Your Honor's considerations.
Court will keep bond as set in the amount of $7,500 as to sale of heroin and $2,000 as to manufacture. Anything further?
no, Your Honor.
No, Your Honor.
All right, thank you very much. Warrant. Next case I have is Nico Vega Fuentes.
Your Honor, he or she's in detox. We'll reset it for tomorrow.
Is this another one in detox, or is that, or are there two?
It's another one in
All right.
detox.
Next case I have is Nico Vega Fuentes, second case.
Same deal, Your Honor.
Right. What I have is, the last case is John Seacrest.
Yes, Your Honor. He's on his way up here, Your Honor. It'll be about a minute.
All right.
Side of county warrant.
Okay. Mr. Segrest, you are here for an initial appearance on a warrant related to charges of extortion, distribution of obscene material, transmitting harmful material to a minor, and sexual cyber harassment. You have the right to remain silent. Anything you say can be used against you. You also have the right to an attorney, and if you cannot afford one, one will be appointed for you. Do you request the court to appoint the public defender to represent you in this matter?
Yes, I do, Your Honor.
All right, the court appoints the public defender. This is on a warrant, probable cause having been determined. Does anyone wish to be heard? State?
Yes, Your Honor. Considering the defendant's current crimes, all of which are serious, all of which have the potential to cause grievous harm not only to members of the community but are most vulnerable, the state would also direct the court to the defendant's criminal history. The defendant in 2016, in October, was charged with multiple counts of aggravated assault with a deadly weapon. He then subsequently was convicted of 2 such offenses March 10th of 2017. The state would also note that the defendant has 2 prior domestic violence injunctions against him. The information available to the state noted in the rap sheet indicates that the particular defendant in this case, Mr. Segrest, is a violent felony offender of special concern with a history of violence. The state would point to what the state previously addressed in the Florida Constitution with regards to Article 1, Section 14, noting that if no condition of release can reasonably protect the community from the risk of physical harm to persons, and would note also the rules of criminal procedure, specifically Rule 3.131, which also provides that if there cannot be sufficient conditions, if the crime is grievous enough, if the defendant's history causes such grave concern to the court, that the court may hold the defendant without bond. And as a result, Judge, the state would ask that the defendant be held at 0 bond, that the court set the bond there, and that if the defendant wishes to leave the custody of the state and of the court systems, he simply do so through his trial counsel, through the appropriate means in the actual court in which he is charged.
Just so I have an understanding, and I'll give the defense an opportunity to contribute in a moment, but there are charges, there's the violation of probation related to the underlying counts of aggravated assault with a deadly weapon, as well as additional charges that I just read into the record?
Yes, Your Honor.
Okay.
Well, Your Honor, I'm sorry, in terms of the violation of probation, you said?
Yes.
State isn't aware of a violation of probation. The paperwork is somewhat labyrinthine with regards to Mr. Segrest, in part because of his history and his extended criminal history, not only within the state of Florida, but also various violent offenses outside the state of Florida. The state isn't aware of a specific violation of probation charge, but simply asks the court to consider the history of the defendant, which is part of the Florida state statute sections that govern how a court determines whether someone should be held with or without bond.
For the defense, I mean, am I misreading something? I mean, there's a
Yes,
violation
Your
of
Honor.
probation
No.
issue with respect to the aggravated assault claims.
That's correct. Yes, he's got 2 cases. The ag assault VOP for that one's currently set at no bond. Then the new law charges that you named out earlier set bond at $11,000 currently, and we ask Your Honor to set that state bond at $11,000 on that case.
I still cannot find that VOP in my own files, but the state would note that the VOP should remain at no bond, as per the cases discussed earlier, and would ask the court to also set the bond in this case as to these new charges, also at no bond.
Defendant will be held on no bond related to the violation of probation with respect to the underlying counts of aggravated assault with a deadly weapon for further proceedings. In the trial division, court sets bond with respect to the new charges of extortion. Court sets bond as to the claim for extortion in the amount of $10,000, distribution of obscene material to a minor in the amount of $5,000. transmitting harmful material to a minor in the amount of $5,000. Strike that. As to the first count, $25,000. As to the second count, distribution, $5,000. As to the third count, transmitting harmful information, $5,000. And as to the cyber harassment claim, $2,500. Should be $37,500. Conditions, no contact with the victim, directly or indirectly. Anything further?
Nothing from the
Nothing
state.
in defense.
All right, thank you very much.
Thank you, Your Honor.
Judge, do you know what time you're going to be starting tomorrow?
I mean, I always shoot for 11, but it looks like I was a little wide of the mark today, so maybe 12, between 11 and 12.
That'll work, Judge, that'll work.
Thank you, Your Honor.
Have a good day.
Well, I'm sorry, counsel, public defender.
I'm sorry, Judge?
Just remind me, we were resetting Santana Brito for tomorrow?
Give me one moment, Judge. Yes, Judge.
As well as Nico Vega Fuentes. Okay, great, thank you very much.
Thank you.
All right, I'll answer questions one at a time. All right.
Taylor.
Got all my scribbles on it.
It's fine. Francis. She went first? Yeah, she went first.
All right. Good morning. We're here in 2020 CF 887 for an initial appearance in the matter of State of Florida versus Joseph Anthony Francis III. Sir, you have the right to remain silent. Anything you say can be used against you. You have the right to communicate with family and friends, and we can make accommodation for that purpose if you need to do so. You also have the right to an attorney. Have you retained a counsel to represent you in this case?
Yes, good morning, Your Honor. Nicole Dickerson for Mr. Francis. I've previously filed a notice of appearance. We will waive reading of the charges at this time. I've spoken with the state. We've agreed to stay all of the bonds as currently set, with the exception of what appears to be count 3, the trafficking charge, and we've stipulated to a bond in the amount of $50,000 on that charge.
Okay, so that brings count 3 down from 200,000 to 50,000?
Yes, Your Honor, and then all of the other bond amounts to be stayed at the same amounts.
Probable cause has been determined. The court will stay the bonds as to counts 1, 2, 4, 5, and 6. And is that consistent with your understanding of the agreement reached with defense counsel, state?
Yes, Your Honor.
All right. And the bond on count 3 will be set at $50,000.
Thank you, and that's all I have. May I be excused?
Anything further from the state?
No, Judge.
You may be excused. Have a great day.
Thank you.
Take care. Thank you, sir. Is this an interpreter case?
Yes, Judge.
All right. Madam Interpreter, are you on the line?
Yes, Your Honor.
All right, Sergio Alejandro? Okay, you are here for an initial appearance today on a charge of battery. The court has reviewed the charging affidavit and finds probable cause for the offense alleged. You have the right to remain silent. Anything you say can be used against you. You have the right to an attorney, and if you can't afford one, one will be appointed for you. Do you wish for the court to appoint the public defender to represent you?
Yes.
The court appoints the public defender. Again, finds no probable cause.
I'm sorry, what was that last bit, Your Honor?
I'm sorry?
I'm sorry, what was that last?
I was
bit?
just restating that the court finds probable cause.
Thank you, Judge.
State wish to be heard as to bond?
Yes, Your Honor, the state is concerned not only by the allegations, which also constitute, in addition to the actual battery taking place between the defendant and his girlfriend who lives with him, but also an attempt to prevent her from grabbing her phone to notify the police. The state believes that the defendant poses a threat to the victim in this case, who, as the state noted, actually cohabitates with him. As a result, the state would request that the defendant be held without bond, or in the alternative, if Your Honor does impose a bond, to be held or rather to have a bond issued that is appropriately high enough to guarantee the defendant's good behavior going forward, and also to impose pretrial release conditions to add an additional layer of protection to the victim, including no contact with the victim.
He qualifies for PTR?
Your Honor, if I may, Jeanette Castillo with the Public Defender's Office. It appears that Mr. Alejandro has no previous history, according to the PTR report that I have in front of me. Although contact with the victim was not established, we're asking that you order no hostile contact in the event that he has to go back for his things. In the alternative, we ask that you order that they maintain separate residences. This doesn't appear to be an offense that warrants no bond.
And, Your Honor, the state would request that the court keep it to no contact whatsoever. Were the defendant to need to return to the residence in order to get his things, as defense counsel said, defendant would be able to, for instance, have an escort from a law enforcement officer or something along those lines to further facilitate not only the defendant being released, but also him actually maintaining the separation required of him by the state.
Court will set bond at $500. Order victim and the defendant to maintain separate residences, no contact, and the defendant will be permitted to return to the victim's residence accompanied by law enforcement personnel in order to receive any personal belongings. Anything further?
Nothing further, Your Honor.
No, Judge.
Thank you. All right. I'm sorry. Victor Morales? Good afternoon, sir. You're here for an initial appearance on a charge of domestic violence battery. You have the right to remain silent. Anything you say can be used against you. You also have the right to an attorney, and if you cannot afford an attorney, the court will appoint the public defender to represent you. Do you wish the court to appoint the public defender to represent you?
Yes.
You're nodding, yes? Okay. Court appoints the public defender to represent Mr. Morales. I've reviewed the charging affidavit and find probable cause for the offenses alleged. Does the state wish to be heard as to bond?
Your Honor, there may be a victim that wishes to make a statement.
All right, thank you.
Also, Your Honor, he qualifies for PTR.
Good afternoon, ma'am. Can you hear me?
Yes, but
She's gonna need the interpreter, Your Honor.
Buenas
Okay.
tardes, señora.
sí, lo puedo escuchar. Buenas tardes.
Yes, I can hear you. Good afternoon.
Okay, great. The offense for which Mr. Morales has been charged is an offense involving domestic violence.
El ilícito por el que se acusa al señor Morales es un ilícito que incluye violencia doméstica.
Sí, eso es cierto.
As-
Yes, that is correct.
And you, as the alleged victim of domestic violence, have some input as to what the court does with respect to the setting of bonds and the conditions of Mr. Morales's would-be release.
Usted, como es la presunta víctima del ilícito, tiene cierta influencia sobre lo que decida el tribunal con respecto a la fianza y a las condiciones bajo las cuales él debe ser puesto en libertad.
And what that means is the court is here to listen to whatever you have to say, but you also don't have to say anything. So are you just here to observe, or is there something you'd like the court to know?
Eso significa que el juzgado escuchará cualquier cosa que usted quiera decir, pero a la misma vez usted no está obligada a decir nada. ¿Usted ha venido en el día de hoy simplemente a observar o usted quiere decir algo?
Quiero hablar.
I would like to speak.
All right, if you'll raise your right hand and be sworn.
Levanta la mano derecha, señora, para prestar juramento.
Do you swear to tell the truth, whole truth, and nothing but the truth, so help you God?
¿Jura decir la verdad, toda la verdad y nada más que la verdad? ¿Lo juro ante Dios?
Lo juro.
I do.
Please state your name for the record.
Señora, diga su nombre para que conste en actas y ya puede bajar la mano.
Daniela Mendoza de Malpica.
And what would you,
Daniela Mendoza de Malpica.
and ma'am, what would you like the court to consider?
¿Qué quiere usted, su señoría, que el juez considere? Señora, perdón, que el juez considere.
Yo quiero paz. Para mí y para mi hijo. Yo,
I want-
el día de ayer, 14 de febrero, por primera vez, tomé la decisión de llamar a la policía cuando él me dio una cachetada. No fue la primera vez que lo ha hecho. Yo sé que él me puede matar a mí. Y todo eso mi hijo lo ha presenciado. Yo merezco una vida de verdad. Una vida lejos de la violencia, de un alcohólico. Yo merezco ir a la iglesia con mi hijo, con un buen esposo. Yo merezco paz.
Señora,
en
me
mi
tiene
vida.
que dejar traducir, por favor. I want peace for me and for my son. On yesterday, February 14th, for the first time, I decided to call the police when he slapped me on the face. It wasn't the first time that happened. I know he could get to the point of killing me. And all that has been going on in the presence of my child. I deserve to have a life away from violence, not living with an alcoholic. I deserve to go to church with a good husband. I deserve peace.
All right, so ma'am, if I understand you correctly, you're requesting that Mr. Morales have no contact with you or your family?
Señora, si la he entendido correctamente, usted lo que está pidiendo es que el señor Morales no tenga contacto ni con usted ni con su familia.
Sí.
Yes.
All right. Does the state have any questions?
Yes, Your Honor. While the defendant may qualify for pretrial release, the state notes the fact that this is a repeated pattern of behavior, as stated not only by the victim to here today, but also by the victim to the law enforcement officers that responded. The victim represented to the law enforcement officers that there is constant arguments in the house that always become violent, and has noted that the pattern of behavior seen here today, seen yesterday in the home, was not at all an isolated incident. And the report indicates that the child here with the victim today was also present during the actual commission of the crime. Your Honor, the court is entitled to look to not only the nature of the offense, but the previous behavior of a defendant and the danger that he poses to others when considering whether and in what amount to set bond. The state would recommend that this court hold the defendant without bond because of the seriousness of this charge, the seriousness of the history, and if the court does in fact grant pretrial release, that the court also mandate that there be no contact, that there be separate residences, that if any return is made by the defendant to the shared residence, that it be in the company of law enforcement officers and any other conditions that Your Honor feels appropriate for the situation, considering its gravity and considering its lack of isolation.
All right, thank you. For the
Your-
defense, did you have any questions?
Not a
of the
question,
victim?
Your Honor, but Mr. Morales has advised that although they live together now, he does have somewhere else to reside. Should you order that they maintain a separate residence, he would have to go back for his things, obviously with police escort. No contact with victim is fine. And although the victim did testify as to previous behavior, we don't have record that he has any previous convictions, any previous criminal records that would warrant no bond. We ask that you allow him to be released on PTR, and if that is not suitable for this court, that we ask that he be released on bond, reasonable amount.
Yes.
Because the defendant, if he is ordered no contact with the victim, we don't have an alternative address for him. And so if you could, to make sure that he would be released, if he is to get PTR, could you order bond or PTR if qualified? So that would give us the ability to verify his alternative address before we were to release him on PTR.
Your Honor, if I may, we don't need a bond amount for him to be able to provide and verify an address upon release. So we'd ask that PTR without bond still be allowed.
Say that again?
We don't technically need a bond number for him to be able to provide an address and for us to verify that that's an actual address he can go to and that is somewhere he can be found pending his court dates and, resolution of this case. So we ask that a pretrial release without bond, it's not, that bond be not be set.
Doesn't the address have to be
Yes, sir.
sufficient?
It would be bond or PTR. So the bond is, so he would have a way out in case we could not verify the PTR address. So he'd have both bond or PTR, not bond and.
Okay, just making sure.
Yeah.
All right, the court will set bond at $500 or PTR if he qualifies. Victim and defendant are directed to maintain separate residences. Defendant is to have no contact with the victim. And no return to 708 Crystal Drive, Ocoee, unless accompanied by a law enforcement officer for the purposes of obtaining Mr. Morales's belongings.
And Your Honor, that was no contact just with the victim or also with the child, the minor child?
Absolutely, as to the victim and the child. I think that's what you requested, ma'am, correct? Madam Interpreter?
Señora, eso fue lo que usted solicitó, ¿verdad? Previsión de contacto con usted y con el menor. Eso es lo que usted pidió, ¿verdad?
Yo creo que él debería de estar preso.
I think he should be in jail.
All right, thank you.
Gracias.
Señor.
All right, Jorge Garcia Cabrera. Hello, sir. We're here this afternoon on initial appearance with respect to a charge of open container. You have the right to remain silent. Anything you say can be used against you. You also have the right to an attorney. If you can't afford one, an attorney will be provided for you. Do you wish for the public defender to be appointed to represent you with respect to these charges?
Yes.
All right, court appoints the public defender, finds probable cause based on the arrest affidavit.
Your
State,
Honor.
go ahead.
Sorry, this is an open container city violation. If we could either give him an offer to resolve this with credit time served today, or release him on ROR.
State have an offer?
Your Honor, the state is prepared to offer a withhold of adjudication and court costs, if that's acceptable to the court and to the defendant.
That acceptable?
Yes.
All right. Do you-
Can I enter an oral plea, or would you like him to get a plea form?
Do you have a plea form?
We don't have one in Spanish available.
Do we have any? Okay, we can do it verbally then. Madam Interpreter?
Yes, Your Honor.
All right. The state, Mr. Garcia Cabrera, is offering to withhold adjudication and to impose court costs. And is it your intent to agree to plead no contest to those charges?
No, no contest.
All right. And do you understand the rights that you're giving up by entering the plea, including the right to present evidence that might establish your innocence?
Sorry, Your Honor, if we could have 1 second. So I can-
Sure.
Go ahead, Your Honor, if you could repeat the question, please.
Do you understand the rights that you're giving up by entering a plea to the charge, including the right to a trial as to your guilt or innocence?
Yes.
All right. And do you understand that if you're not a U.S. citizen, the plea may subject you to deportation?
Yes.
All right. Court finds that...
Well, I am, well, yes.
Go ahead. I thought I heard him say yes, but you can go ahead and translate.
Well, I am, well, yes.
Okay. Court finds the basis to accept the plea, withhold adjudication, and order payment of court costs.
If we could have up to a year for him to pay, usually the 360 days is allowed.
Okay. State?
No objection, Judge.
All right. Thank you very much.
Your Honor, just so we can give him credit for the 2 days that we spent, if we can sentence him to 2 days and credit for him for the
All right.
2 days.
Sentence of 2 days and credit for time served.
Thank you.
All right. Jeremy Eleazard. Is that you, sir?
This is Garcia.
Which Garcia? Okay.
Demetrio Garcia?
Yes, sir.
Okay, you are here for an initial appearance based on a failure to appear related to an underlying charge of petty theft or larceny. It's not clear to me. You have the right to remain silent. Anything you say can be used against you. You have the right to an attorney, and if you can't afford one, the court will appoint the public defender to represent you. Do you want the public defender to represent you, Mr. Garcia?
Sí.
Court appoints
Yes.
the public defender. Any input from the state?
Yes, Your Honor, because this is a failure to appear warrant, the bond amount of $0 cannot be changed by the IA judge, and as a result, the state requests the court to keep the bond as is.
Anything from the defense?
Yes, Your Honor. Defense is okay with the no bond on the failure to appear, but it looks like he has an open container charge. If we could release him on ROR as to that.
Any objection, state?
No, Your Honor.
He has a bond on the FTA is what I'm being told. So if we could honor that bond. It's a $500 bond.
He does.
I see. My information says 0, but if there is in fact a bond already set, whatever that bond is, should be left in place by the court.
All right, Mr. Garcia will be released on his own recognizance with respect to the open container charge, and bond will stay on the failure to appear charge in the amount of $500. And court finds probable cause with respect to the open container charge. Anything further?
Nothing further, Your Honor.
No, Judge.
Great, thank you.
I don't have them on the line, but that's the top of the movement. So you get the Creole on the line, that's the top of the movement. Yeah.
What happened with Awad?
They're gonna go with
Awad, the DB?
Jared.
Okay.
Who is that? Freeman. First person on the list.
Right.
I'm
State of-
sorry, Your Honor, may the Spanish interpreter be excused?
Last one, that was the last one? You can be excused, ma'am. Did
Thank
I
you,
hear
Your
something
Honor. Have a good
about a Creole interpreter, though?
Yes, we have Mr. Creole, which is she helped them.
Okay. Not for this case?
Thank-
All right. Well, we are here in State of Florida versus Jonathan Michael Freeman, 2020 CF 1500.
Your Honor, I'm sorry, if I can interrupt, he's already requested the PD be appointed on his case, and we'd ask for a formal waiver of the reading of the charges.
All right. Defendant waives reading of the charges.
Thank you. And then as to the charge, it looks like there's a victim under 12. The victim's actually 13 is what I'm being told, so I don't know if we can correct that, but there would be no PC as to that specific allegation
So you're challenging PC with respect to that claim?
to the age, yes.
Is this, which defendant is this? This is Freeman?
Freeman.
So if we have a date of birth listed, that we can check to confirm that was information I was just given.
Okay, as a matter of the record, the court appoints the PD to represent Mr. Freeman. The court previously found probable cause with respect to the charges, and now probable cause is being challenged as to the claim for lewd one of the claims relating to the victim under the age of 12. Can you speak to the bond state?
Your Honor, with regards to the specific allegation of the victim being under 12 years old, I'm seeing from the affidavit actually filed that the victim was 13 and that the charge recommended by the affiant was lewd and lascivious molestation on a child under 16. In terms of the specific bond on that charge, Your Honor, the state repeats what the state has repeated before about the importance of protecting not only the community, but the most vulnerable members of the community. That would include a child. The state would also note, reading the application and affidavit for arrest warrant, that the detective that responded to the scene established that there is a very close relationship between the defendant and the victim, that the defendant and victim are in frequent contact, that the victim pulled away from the defendant. Indeed, the affidavit also indicates that the victim told the detective that the defendant has repeated this behavior many times before, that she has been touched, in fact, in a manner by her uncle, who I believe is the defendant, in a manner that she does not want, quote, more than 20 times. And that, quote, every weekend he does something that makes her feel uncomfortable. The detective notes from her extensive training and experience that this behavior is consistent with the grooming of the child. Considering the severe risk posed to the child, considering the fact that molestation of a child is in fact a very serious offense. I don't recall if under 16 specifically is one of the enumerated dangerous crimes that is specifically listed and enumerated in the statute as a crime that should not be granted non-monetary bond in any regard, but it is a serious offense. The state would request that the defendant be held without bond and be able to file a motion at a later date once it is clear both to the defendant, to the defense counsel rather, and to the state and to the trial judge whether the defendant is actually safe in the community and presents a threat to the child in question. The state would note that the charge is one deserving of the utmost seriousness and respectfully requests that the court honor that seriousness by keeping the defendant within custody until further investigation, further motions, and further testimony can be gathered by the trial court.
Well, so how does that affect your challenge to PC? I mean, if it's charged as under 16, whether or not the victim was 12 or 13 is irrelevant, right?
So my understanding is that I had under 12 years old, and she's not under 12 years old, is what I had on this paper. And then as to the affidavit that we have now all read, it does say that bond may be set at the bottom. It doesn't say that they are asking for no bond. It's also my understanding that the victim and the defendant do not live in the same household. It looks like the relationship there was an uncle-niece relationship. The victim does spend time with her mother, so we're asking that the court order no contact with the victim, that they maintain separate residences pending the resolution of this case. And we also ask that you do set bond at a reasonable number.
And, Your Honor, the state would note that because of the fact that this is a first-degree felony, it should be interpreted as essentially towards a vantage point of not proverbially letting the horse out of the barn. Taking a more drastic measure now is preferable to taking a lighter measure than may be warranted, because if the defendant is released and does manage to make contact with the victim, does manage to injure or again molest the victim, that damage will have already been done. Whereas if the court takes a stronger stance now and permits the trial court to delve into the matter with more detail, the potential consequences are dramatically lessened, and it would be in the interest not only of the state and of the courts, but also of society and the community to keep the defendant in custody.
Your Honor, it looks like the defendant was the arranged transportation to and from parents' house and from school. I'm sure that the parents have taken measures to remove that condition. and that arrangement. So we're asking that you order no contact, and that should be sufficient to prevent any foreseeable, if any, occurrences in the future.
Okay, so the probable cause determination notwithstanding, the arrest affidavit includes a charge of under 12 years of age, but the arrest affidavit, or the arrest warrant, found probable cause for the claim under Section 800.04 sub 5B, lewd and lascivious molestation on a child under 16. So the court's found probable cause as to that, and the age of the child being 12 or 13 is irrelevant as to that charge, and this court doesn't disturb the court's prior finding with respect to probable cause. The victim's mother would be the defendant's sister,
I believe
accurate?
it's a father.
Father?
Yeah,
Okay.
correct. The niece, she's your brother's son,
Yeah.
daughter?
All right, court will set bond in the amount of $50,000, direct no direct or indirect contact with the victim or the victim's parents. Obviously, maintain separate residences to the extent they have not before.
So you can't talk to your parents, you can't talk to her, you can't live with her.
And although it should be wrapped up in maintaining separate residences and no direct or indirect contact with the victim or the victim's parents, no return to the home either, where the victim resides.
Okay.
Is that what you did? Is that what you did?
No.
And the no contact order, to be very clear, includes any electronic correspondence. All right?
And then.
Yes.
I can.
Electronic communication, rather.
At the court. You can fight it.
Anything further?
Nothing further, Your Honor.
No,
All right,
Judge.
thank you. Larry Frederick? Are you Larry Frederick, sir?
Name of.
That's your name? All right, you're nodding. You're here for an initial and appearance related to a charge of trespass after warning. Do you wish for the PD, the public defender, to represent you in this matter?
Ask for the call, it's the same.
All right, court appoints the public defender to represent you. You have the right to remain silent. Anything you say may be held against you. The court finds probable cause for the offense alleged, which was a misdemeanor. What says the defense?
Your Honor, we ask that he be released on bond. I understand that a previously set amount with $500 was set. There are comp concerns, and he may be transient, so we ask that he be released on ROR.
State.
Anything, I know what, like, brother, I had a quick experience.
Your Honor, first, there is in the arrest affidavit a listed address for the defendant in Sanford. Second, the state would note that if there are competency concerns, that's something that can be addressed by the trial court once the defendant is delivered to that court. The state would leave the exact resolution in terms of bond amount, if any, in the court's discretion. However, the state would note that the defendant's criminal history is extensive, with 1 felony, 52 misdemeanors, 5 failures to appear, the most recent one, January 10th of 2012, 60 unknown dispositions, an extensive history of trespass, the charge actually alleged here, resisting without violence, extensive drug paraphernalia, open container, loitering and prowling, and a variety of ordinances in addition to aggravated assault, burglary, grand theft, and other such offenses. While this is simply a trespass on property after warning, the state would note, 1, that means that the defendant was already told explicitly not to return to this location, did not obey that lawful requirement, and 2, that the defendant in this case while he did not commit any more serious crime to the state's knowledge at that location, in this particular instance, apparently has an extensive history of offenses that are often comorbid with trespassing, including burglary and including violent crimes. And the state asks that the court take that into consideration when determining the resolution here today.
Did I understand you to say that a bond had previously been set?
I saw that on the police report, they were set at $500.
There's no if there's no eligibility for standard direct PTR, is there eligibility for mental health PTR, or does one foreclose the other?
I'm sure he's been looked at by mental health, he has a mental health detainer on there. As far as if he were to get mental health PTR, he would be screened by our professionals here as soon as they can get to him. Sometimes that's as early as Monday. So we did not qualify him for PTR, nor have we had in the past. So a lot of times he does completable offenses and suspended the last few months. So no PTRs.
Right. Court will set bond at $250. Anything
You
further?
get it over my R&R?
No, he said.
That's what I'm getting on.
He set it on 250 bond.
And, Your Honor,
I'll get out of the
the state
bond,
would also
try
request,
for to be-
regardless of whether or not it would actually end up being obeyed, an order
Yeah, well,
of
that's
no
what I
return to the
did.
location, no contact with the
Pretty
witnesses.
man seen.
Order of no return to the premises from which he was trespassed.
Oh, what about the R&R? That's right, right?
So it's set at 250, I'm so sorry, but he's saying no. So you're gonna have to attack.
Well, you try to act like the judge, that's the same thing, like, you ain't doing really well.
Hey, Justin.
Yeah.
So you'll get an attorney.
All right, Justin Davis?
No, it's not yours.
Hi. Hello.
Hello. You're here on an initial appearance related to an out-of-county warrant for an underlying charge of petty theft. You have the right to remain silent. Anything you say may be used against you. You also have the right to an attorney, and if you can't afford one, the court will appoint an attorney to represent you. Do you wish for the court to appoint the public defender to represent you in this case?
Your Honor, I'm sorry, he's an out-of-county
Oh.
hold, so he would get one when he returns.
You're right. All right. The defendant will be held without bond pending transfer and further proceedings in Brevard County. Thank you. All right, Willie Edmonds,
Yes, sir.
how are you, sir?
Good morning.
You're here on a first appearance related to charges of an open container and littering on public property. You have the right to remain silent. Anything you say may be used against you. You also have the right to an attorney, and if you cannot afford one, the court will appoint a public defender to represent you. Do you wish for the court to appoint the public defender?
Pardon me?
Do you wish for the court to appoint the public defender to represent you with
What's
respect
that
to the...
city ordinance is?
I think you're saying yes?
That's city
Okay.
ordinance?
He's asking if it's a city ordinance charge and if he could resolve it today.
All right. Court will appoint the public defender with respect to the charges.
I told you to
State.
hurt my ankle, ma'am.
Okay, well, I'm trying to help you. So
You heard me, ankle, and I can hardly walk and he brings it.
Your Honor, the description given in the face sheet does not have too much in the way of detail. However, considering the nature of the offenses, the state, and looking on the comprehensive case information system at prior offenses, which indicate adjudications for these offenses as well, the state would recommend that the court impose an adjudication of guilt and court costs on both offenses, and 3 days in the Orange County Jail with any day credit for any days already served.
How many days have been served? One.
Your Honor, the allegation is that he had a beer transferred to a 7-Eleven cup. We ask that 1 day credit time served should be sufficient.
And, Your Honor, the state understands the situation and considering relative strength of the case, and whether the state would be comfortable with 1 day credit time served if the judge is willing to impose adjudication court costs in addition to that.
Defense agreeable?
Yes, Your Honor.
All right, do you have the plea form?
I can get.
Pardon? Yes, yes, ma'am. Yes, ma'am. Yes, ma'am. Yes, ma'am. And I am an attorney.
Let's not talk on the record. So if I can have you sign where it says defendant? Oh, sorry.
And I can't tell a type of in. And I'm retired, Your Honor. And this ain't no but harassment. And forgive my behavior. Please, sir. And
All right, and he's circled guilty?
It's a no contest plea, but it's
No
an
contest?
adjudication of guilt.
Okay. Then you understand everything contained in the plea form?
yes, sir.
All right, and you understand the rights that you're giving up by entering a plea?
Yes, sir.
All right.
Fully, I've been through this here many, many times.
Okay, good. I'm glad that you have an understanding of what you're doing. Court
Yes, sir.
finds a basis to accept the plea.
Yes, sir. Excuse me, Your Honor.
You'll plead no contest to the charges alleged. Court adjudicates and sentences you to 1 day credit for time served and imposition of fees. Court cost, rather.
Keep your opinion to yourself. Thank you, Your Honor,
Thank you.
and have a great life.
Richard West?
He's medical, Your Honor.
All right. Is he reset?
How's medical reset, Judge?
Reset.
All right. Is there a specific day or
Tomorrow.
maybe tomorrow? All right.
Yeah. Tomorrow or not tomorrow.
It's usually within 24 hours of his clearing.
All right, DeMarco Wilson?
Yes, sir, Your Honor.
Okay, good afternoon. You are here for an initial appearance with respect to charges of trespass and criminal mischief. You have the right to remain silent. Anything you say may be used against you. You also have the right to an attorney, and if you can't afford one, the court will appoint the public defender to represent you. Do you want the court to appoint the public defender to represent you?
Yes, sir, Your Honor.
All right, court appoints the public defender. I've reviewed the arrest affidavit, and the court finds probable cause for the offenses alleged. State?
Your Honor, the state would leave the exact disposition in Your Honor's discretion. The defendant does have 5 prior felonies, 11 misdemeanors, and 8 failures to appear. Last arrest, 11/18/2011. Your Honor, he has an extensive criminal history, including offenses similar to those charged, including various loitering or trespass charges, 5 trespasses specifically, and a history of some violent offenses as well. State just wants the court to take that into consideration when setting bond.
All right, what says the defense?
Your Honor, it looks like the bond amounts that were set on the police report were 500 and 500 on each count. We ask that the court order they be lowered to 250 each and with an order of no return to the scene,
With what?
in order to not return to the scene.
Was that an apartment complex? Is that what it was?
I think so, and I don't believe there was any relation to the victim.
All right, court sets bond on the trespass count in the amount of $250 and the criminal mischief count in the amount of $150 and directs defendant not to return to the subject apartment complex at 1915 Americana Boulevard. Anything further?
Nothing further, Your Honor.
Thank you very much. All right, Wayne Love?
Yes, sir.
Good afternoon, sir. You're here on initial appearance related to an out-of-county warrant on underlying charges of attempted felony murder, armed occupied burglary, and aggravated battery with a firearm. This is an out-of-county warrant again, so unless there's anything from the state or I haven't appointed you, so if there's anything from the state, the defendant will be held without bond for further proceedings in Brevard County related to the underlying charges, okay? All right, thank you.
I'm saying that you have a failure to appear warrant, contempt warrant, and then introduce a constitutional.
Okay, Mr. Clark? Do you need a second?
Go ahead, Your Honor.
All right, you are here on an initial appearance related to claim of introducing contraband into a county facility as well as a warrant for failure to appear on underlying charges of threats to throw a destructive device for which there is no bond set. You've got the right to remain silent. Anything you say may be used against you. You also have the right to an attorney. I gather just from your conduct that you'd like to have the court appoint the public defender to represent you?
Yes, sir.
All right, court appoints the public defender. Court finds probable cause with respect to the charge for introduction of contraband into a county facility.
Excuse me, Your Honor, can I speak in my behalf?
I'd rather you talk with your attorney first.
Okay, first of all, Your Honor. With that failure to appear, I've been having severe seizures from traumatic head injury. That's the only one I missed that court date. I went to court yesterday. She reinstalled everything and said that all she wanted me to do was make sure that I was complying with going to therapy and psychiatrists and stuff like that. Okay,
and
the
what
civil situation, that's basically for child support that I've been took off 4 years ago. In the introduction of contraband, when the police officers came in and arrested me from the rooming house I was in, basically they basically surprised me or whatever. And when they took me downtown or whatever, and they never searched me.
All right. Let me ask the state for its position with respect to these two, both a existing warrant for failure to appear as well as the new charge.
Your Honor, referring to the cases mentioned previously by the state, the court should not attempt to change in any way the bond amount on the failure to appear. With regards to the offense of introduction of contraband, the state would request that the court take into consideration the defendant's criminal history, 14 prior felonies, 12 prior misdemeanors, There is a very, very extensive drug history involved, including everything from possession of cannabis to possession of various controlled substances. And the state would simply request that the court, in making its determination, determine an appropriate bond amount.
Defense?
Your Honor, it appears that the failure to appear could have been not voluntary if he's having medical seizures and a lot of medical issues that are happening. We ask that you set bond on all counts.
And Judge, the state can provide the citations again for the foundational assertion that the court does not have the authority to alter the bond on the failure to appear. If his failure to appear was not willful, that's something that can be addressed in trial court.
Court will set bond in the amount of $250 with respect to the introduction of contraband claim and is constrained to take no action with respect to the failure to appear charge, and the defendant will be held on no bond related to the failure to appear charge until further proceedings can be held in that case. Thank you very much.
The introduction to contraband, he gave you 250. The FTA, 0, and the civil commitment. You're gonna have to talk to your attorney when you come to the jail.
Okay, but that's what I'm saying. If they screamed this out yesterday at the courthouse, come out, I'm not even on trial.
He's not gonna change his
Okay. AJ Brooks?
Yes, sir.
All right, you are here for an initial appearance related to a charge of disorderly conduct. You have the right to remain silent. Anything you say may be used against you. You also have the right to an attorney, and if you don't have the means to afford an attorney, the court can appoint the public defender to represent you. Do you wish for the court to appoint the public defender to represent you?
Yes, Your Honor.
Court appoints the public defender. Court finds probable cause with respect to the conduct alleged. What says the state?
Your Honor, the state for this particular defendant would have an offer available of adjudication, court costs, and credit time served if the defendant is interested. Besides that, the state leaves it within Your Honor's discretion.
I'll take it.
I'll prepare the plea form, Your Honor.
Thank you. All right, Mr. Brooks, you've signed the plea form?
Yes.
All right, did you understand everything that was contained in the plea form? And you understand the rights you're giving up by entering into the plea?
Yes, Your Honor.
All right. And you understand that if you're not a U.S. citizen, you will be subject to deportation?
Yes, Your Honor.
All right. Court accepts the plea of no contest. Sentences to the defendant to 1 day with credit for 1 day time served and imposition of court costs. Was it 2? 2 days. All right. Thank you very much.
Thank you, Your Honor.
All right, Brian Foley.
Yes, sir.
Good afternoon. You're here
Even.
for a first appearance related to a claim of open container. You have the right to remain silent. Anything you say may be used against you. You also have the right to an attorney. If you can't afford one, the court will appoint the public defender to represent you. Would you like for the court to appoint the public defender to represent you with respect to this claim?
Yes, sir.
Okay, court appoints the PD.
Your Honor, he'd like to resolve this today if we could have an offer.
All right.
Your Honor, the state's offer would be adjudication of guilt, court costs, and credit time served.
1 day. All right, sir, you understand the plea form that you've signed here today?
Yes, sir.
All right, and you understand the rights you're giving up by signing that plea
Yes,
form?
sir.
All right. And the court accepts the plea, adjudicates you guilty, sentences you to 1 day with 1 day credit for time served, and imposes court costs. Thank you.
Thank you.
All right. Louis Lindsay?
Yes, sir.
Afternoon, sir. You're here for an initial appearance on a charge of disorderly conduct. You've got the right to remain silent. Anything you say can be used against you, and you also have the right to an attorney. And if you can't afford one, the court can appoint the public defender to represent you. Would you like for the court to appoint the public defender to represent you?
Yes, sir.
All right, court appoints the PD. Court finds probable cause for the charge alleged.
Your Honor, he'd like to resolve this today if we could have an offer.
And your state's offer would be adjudication of guilt, court costs, credit time served.
All right, Mr. Lindsay, do you understand the terms of the plea form that you've signed here today?
Yes, sir.
And the nature of the rights you're giving up by entering into that plea form?
Yes, sir.
All right. And if you're not a U.S. citizen, you realize that the plea will subject you to deportation?
Yes, sir.
All right. Court accepts the plea, adjudicates you guilty of the charges alleged, sentences you to, was it 1 day, 2 days? With credit for 2 days' time served and the imposition of court costs. Thank you.
Thank you.
Ramsari Taylor?
That's correct.
All right. You are here for an initial appearance on a claim of disorderly conduct. You have the right to remain silent. Anything you say may be used against you. You have the right to an appointment of an attorney. And if you can't afford one, one will be appointed. Would you like for the court to appoint the public defender to represent you?
No, I represent myself.
Oh, you represent yourself? Okay. What says the state with respect to the charges against Mr. Taylor? The court finds probable cause.
Your Honor, if the defendant wishes to resolve this case today, the state's offer would be adjudication of guilt, court costs, and credit for any time already served. Besides that, Your Honor, in terms of setting any bond amounts or anything along those lines, the state would leave it in Your Honor's discretion.
All right. Mr. Taylor, have you heard the state's offer to you?
Yes, Your Honor.
Did you just sign it?
Yes.
Okay, that was. All right, thank you. All right, do you understand the plea form that you've signed here and the nature of the rights you're giving up?
Yes, Your Honor.
All right, you've responded yes to both questions. The court accepts the plea, adjudicates you guilty of the charges alleged, sentences you to, I'm sorry, I already forgotten, 2 days? 2 days with credit for time served, imposition of court costs to be paid within a year. Thank you very much. I think we need to take a break. All right, good afternoon. Christopher Awad,
Yes.
you're here for your first appearance on charges of battery. You have the right to remain silent. Anything you say may be used against you. You have the right to an attorney, and if you can't afford one, the court will appoint the public defender to represent you. Would you like for the court to appoint the public defender?
Yes.
All right, the public defender is appointed.
Your Honor, he qualifies for PTR. And the victim is here, but in the police report said she didn't want to prosecute, so I don't know if she has any,
Okay.
any testimony.
Ma'am, what's your name?
Masha Nanan,
Could you spell the last name for me so I get it right?
Nanan.
Nanan. Okay. Will you raise your right hand, please? Well, before we get to that, this claim involves, or this charge rather, involves potential domestic violence, and because of that, you've got certain rights for the court to hear what you have to say in order to take that into account in determining how things unfold here. That having been said, you don't have to say anything. You can simply come here to observe because it implicates your rights as well. Do you have anything that you want the court to know in determining how to handle these particular charges at this procedural juncture?
Yes.
Okay, if you'll raise your right hand.
Do you swear to tell the truth, whole truth, and nothing but the truth, so help you God?
So help me God.
What would you like the court to know?
I am not a victim of domestic violence. I did not call the cops. I do not want him here. He should not be here. I'm very upset with the Apopka police. He didn't do anything wrong.
Does the state have any inquiry of Ms. Nanan?
I'm requesting to dismiss the case.
Your Honor, the state does have a brief inquiry, if the state may. Good afternoon, ma'am. For how long have you known the defendant?
Since I was 10 years old, he is my first boyfriend. I'm in love with him.
All right. Has anything similar to this happened in the past?
No.
All right. Are you afraid of the defendant?
No.
All right. Have you ever been afraid of the defendant?
No.
Okay. Do you live together with the defendant?
I'm sorry?
Do you live together with the defendant?
Yes.
All right. Okay. Are there any weapons in the home?
Yes.
Okay. What sort of weapons?
I'm West Indian, so we have cutlass, like knives that we use for the grass. And there is one gun.
All right. What kind of gun is that?
I don't know.
Okay. No further questions, Judge.
Anything from the defense?
Yes, Your Honor, based on the testimony we've heard today and the allegations, we ask that he be released on ROR and not PTR. There doesn't appear to be any fear in the home. It looks like it was possibly a misunderstanding. Victim is present, clear in her testimony. It looks like she is firm in her intentions. She's even stated she does not want to press charges against Mr. Awad.
And, Your Honor, by way of argument, the state would note that the law enforcement officer in this case responded to a call about a disturbance. It's clear that if there was some sort of misunderstanding, it was a public one, and it was one in which someone felt it was appropriate to notify law enforcement. The state does not object to releasing the defendant, but asks that the court do so on pretrial release with the condition that there be no hostile contact. So that the victim, if anything changes, if there is any sort of future incident or something like that, would have a recourse.
Your Honor, if I may, the recourse would be to call the cops.
The court will release Mr. Awad on his own recognizance. Is there a further date? Never mind. That's it. Thank you.
Nothing further.
No.
Were we able to get a Creole interpreter? The Creole interpreter, were we able to get a hold of them? I do it in court too. I have to stop.
Madam Interpreter?
Yes, Your Honor.
Hello. Did you already? All right, you've been sworn. The record will reflect. Is this Mr. Desane or Mr. Eleazard?
Allô, bonjour.
Allô, bonjour.
Bonjour. Moi, vais l'interpréter vous. Donc, où est le monsieur Dessin ou bien monsieur Eleazar?
Harrison Desane?
Mr. Eleazar.
Oh, Eleazar, okay. All right, Mr. Eleazar, you are here for a first appearance related to a charge of aggravated battery. You have the right to remain silent. Anything you say may be used against you. You also have the right to an attorney.
Ok, donc, pour là, comme mon premier apparence, à cause de une charge de batterie aggravée, et ou obligé de rester silence, tout sorti capable d'utiliser contour. Alors, ou gen droit pour rester silence, tout sorti capable d'utiliser contour, et ou gen droit pour un avocat, si vous voulez.
Oui. And if you cannot afford an attorney, the court can appoint the public defender to represent you. Is that what you want the court to do?
Donc, si vous pas gen l'argent pour prendre un avocat, et le tribunal là capable de ou ça un défenseur public. Est-ce que vous voulez pour yo ba ou défenseur public là ou bien on prend un avocat ou?
On va un défenseur public là.
Okay, so the public defense.
All right, court appoints the public defender to represent Mr. Eleazar.
He does qualify for PTR.
All right, court finds probable cause. What says the state?
Your Honor, the facts as alleged within the arrest affidavit are shocking. The state would ask the court to take note of the fact that Florida state statutes allow courts to detain defendants without bond if they present a serious threat to others. The state has previously noted
Slow
sections.
down, give the interpreter just a second to catch up with you, please.
Oh, I wasn't catching up at all. So can you please just restate it slowly?
Yes, Madam Interpreter. The state notes that the facts alleged are shocking.
Ok. Donc, l'État remarqué ou bien noté que tout fait que yo dit contre ou même yo vraiment choquant.
Because of the seriousness of this crime and because of the facts in which it occurred,
À cause de sériosité crime nan et à cause de fait que vraiment crime nan t'est fait.
the state notes for the court that courts have the power to hold someone without bond.
Bon, et l'État fait remarquer que tribunal là gen droit pour yo capable kembe yon moun sans que yo pas mette yon prix pour yo lage moun nan. Yo gen pouvoir ça.
Both the Florida Constitution and the Florida Rules of Criminal Procedure permit courts to hold defendants without bond if they present a danger to others.
Donc, ni constitution dans l'État Floride, ni règlement pour procédure criminelle dans l'État Floride, yo tout yo dit que si tribunal la vle, yo capable kembe yon moun sans que yo pas jambe bay ou bien déterminer yon prix pour yo lage moun nan, si toutefois ça moun nan fait a, li tellement grave et li cause yon danger pour société a.
Additionally, Your Honor, the facts alleged include the defendant being charged with tampering with the victim's ability to contact law enforcement.
Can you please restate that again?
The facts, as alleged, include that the defendant attempted to stop the victim from contacting law enforcement.
Okay. Thank you. Donc,
Yes,
fait yo dit que moun nan ki an toran li te empêché moun nan ki victime nan pour le contacter autorité.
Because of the fact that this case is so serious and because of the threat that the defendant poses,
Bon, à cause que cas tellement grave ou bien cas tellement sérieux et pour moun qui défendant pour toute menace que défendant fait,
the state asks the court to hold the defendant without bond until a hearing can be held in the trial court.
l'État mande à cause de gravité problème nan pour yo kembe li sans yo pas déterminer yon prix pour la guéri jusqu'à ce que yon audience capable faite pour le paraître devant tribunal.
Defense?
Yes, Your Honor. It appears that, I just want to note, he works for Disney. It doesn't look like he's got any criminal history at all. It also states here on the PTR report that he has a low risk assessment to reoffend. He does qualify for PTR, so we're asking that he, oh, I'm sorry, Creole interpreter. Thank you.
Okay, I'm gonna stop at the low risk assessment to reoffend.
Okay.
Okay, thank you. Donc, il paraît que défendant la travail dans Disney et il paye pièce dossier criminel et puis tout risque pour le capable refaire yon bagay comme ça, yon offense comme ça, il très bas.
Okay. Because of this, we ask that he be released on PTR as recommended.
What is PTR, ma'am? I
Pre-trial
apologize.
release.
Pre-trial, okay. Donc, à cause de tout bagay sa yo mande que yo lâché défendant avant jour jugement.
Yes, sir.
This is pretrial, Your Honor. He does qualify for pretrial, but we don't have an alternative address for him, so if you do choose to use.
I can't hear him, Your Honor, so I can interpret. I apologize.
Your Honor, if you do choose to choose pretrial, can it be a PTR, a bond or PTR if qualifies again, so we can establish an address? Yet, right now, he has no alternative address. If you were to do that, Your Honor. Thank you.
Okay. Donc, si toutefois, Majesté wap la gen li, konen ke li pa genyen, yon lot adres pou la li.
Your Honor, due to the lack of history, it appears that this might have been an isolated incident. We ask that we adhere to the recommendation.
Can you please repeat that, ma'am?
Due to the lack of history, it appears that this might have been an isolated incident, and we ask that we adhere to the recommendation of pretrial release.
Oh, thank you.
You're welcome.
Donc, le fait que manque fait ou bien pas gen yon historicité de zak comme ça, donc il paraît que incident c'est un incident ou bien un cas très particulier yo mande pou yo kapab coopérer avec protocole pour yo relâcher ou avant pour yo ta même faire une audience.
Right. And PTR's had no contact with the victim?
Your Honor, there wasn't at one point, but I believe our officer continued and said,
I cannot hear that. I cannot hear you.
the community ties and residents were verified through Orange County property appraisers, no victim contact.
Bon, selon recherche que yo fait dans la communauté Orange County, yo pas remarqué que te gen pièce contact avec victime là.
Defense asks that no hostile contact be found sufficient.
Court.
Donc pas gen pièce contact hostile que yo te joindre qui assez suffisant comme preuve.
Court will order pretrial release with no hostile contact.
What was that?
Court will order pretrial release with no hostile contact.
Thank you. Donc, tribunal l'a demandé pour yo relâcher avant jugement fait, mais sans pas de pièce contact hostile.
All right, thank you.
Merci.
All right, Farisine Desane. You are here for your first appearance related to charges of aggravated battery on a pregnant woman.
Bon, ou là parce que ou gen yon charge de batterie aggravée contre yon femme enceinte.
You have the right to remain silent. Anything you say can be used against you. You also have the right to an attorney, and if you can't afford one, the court may appoint the public defender to represent you.
Bon, ou gen tout droit pour capable rester en silence parce que tout sorti capable d'utiliser contre et ou gen droit tout à un avocat ou bien ou capable faire tribunal là-bas ou ça un défenseur public sous pas gen avocat.
Would you like the court to appoint the public defender?
Est-ce que vous voulez pour tribunal là-bas ou un défenseur public?
What did you say, counsel?
He's out of county, Your Honor.
He is?
Yes. If it's Osceola, yeah, we can appoint, but I don't have the county in front of me. I just see
Yeah, it
he's
says
on
Osceola on what I'm looking at. So
here. Okay.
court will appoint the public defender.
Donc, le tribunal là-bas ou un défenseur public.
And the court finds probable cause for the offense alleged in the arrest affidavit.
Bon, yo joignent cause des causes probables pour toute allégation qui fait yo dans mandat d'arrestation que yo te ba ou.
All right, can I have the state's input as to bond?
Yes, Your Honor. Seeing as how this is pursuant to a warrant, the state requests no bond so that he can go to court as required of him out of county.
OK. Donc, selon Jean qu'a présenté, yo mandé pour pas gagner yon l'argent qui déterminé pour la gueule dans prison. Donc, jusqu'à ce que l'y paraisse devant tribunal là pour jugement.
I don't have a bond, I'm sorry, a warrant.
There was no warrant, Judge?
Oh, I thought that's what you said.
Oh, I'm asking you, Judge, you said there's no warrant?
I don't have any, I'm not looking at what I have in front of me. I'm not seeing a warrant. Is there a warrant?
I was under that impression, Judge. I can double check that.
Your Honor, if I may, it looks like the PTR, he's not eligible for PTR, but the risk assessment results were below average. He's not, Creole interpreter. Sorry, I'll slow down.
Okay. Okay. He's not, can you state that
He's
again?
not eligible for PTR, pretrial release.
Mhm.
However,
Okay. Donc, oh, sorry.
however, the risk assessment results are below average, and he has no history.
Ok. Donc, li pa éligible pour li lage avant yo présente alors yo fait le présenter dans jugement, li pa éligible pour ça. Mais seul bagay risque yo très bas et li pa gen pièce historicité criminelle.
He's also a resident of Kissimmee, Osceola County, and his length of employment is 18 years, so I'd argue that he can be responsible and appear to any court date set by the court.
Ok. Donc, c'est un résident de Kissimmee, de Osceola County, et il gagne 18 ans et depuis la vive là. Donc, moi, argumenté que il croit que il est capable et responsable assez pour le capable présenter dans jugement.
We ask that you set bond.
Bon, moi, demandé pour capable mettre un prix pour yo la guérir dans prison.
Victim is in the hospital? It was a what? Okay.
And Your Honor, the state would request that if the court does set a bond, that it adequately reflect the seriousness of the charge of aggravated battery on a pregnant person, domestic violence. The state would also be asking for no contact and no return, except accompanied by law enforcement.
Bon, et si toutefois ou déterminez un prix pour yo capable la gueule dans prison, donc moi demandé que l'État capable et faire remarquer que gens que cas grave que gagne c'est un cas côté que batterie aggravée ou une femme enceinte et pas une pièce contact qui doit être faite à moins que l'y accompagné ou bien escorté par la police.
All right, court sets bond in the amount of $1,000.
Bon, tribunal là, mettez l'argent pour yo la gueule dans prison, montant c'est $1,000.
No contact with victim or her mother.
Donc, pas entrer en contact ni avec moun qui victime non, ni avec maman victime non plus.
No return to the residence except when accompanied by law enforcement to collect personal belongings.
Ou pas qu'à retourner dans caille là, moins qu'on escorté par la police pour aller chercher affaires personnelles seulement.
Thank you very much.
Merci beaucoup.
Ok, mon question. Oui, j'ai un médicament pour aller chercher la caille là. Puis j'ai un linge pour me récupérer la caille là tout. Je dois accompagner avec des polices, soit aujourd'hui ou bien.
Okay, I have medication to go get back in the house, and I also have my outfit. So may I be escorted today?
Yep, that's consistent with the court's ruling, and your attorney will explain further.
Bon, définitivement, vous capable accompagner monsieur et par police là parce que c'est la loi ça que tribunal là bail et avocat là vient pour expliquer où et plus tard tout bagaille en détail, OK?
OK. Une question encore. J'ai besoin de lettre comme si pour me porter dans le travail, moi, pour me connaître ce que
Okay, may I have a letter to bring to the employer, to my employer?
I'm sorry? Yeah, you can have your client provide his employer a copy of the court order.
If the, is she gone, or can she interpret that?
Oh, I'm here.
The court's order can be provided to the defendant, who can in turn provide it to his employer.
Ok, sure. Donc, yo gen pou yo ba ou yon form pou pote bay travay ou a monsieur. Ok?
Ok, merci.
Thank you.
Thank you, Madam Interpreter. I think that's all.
Thank you for using our services, Your Honor.
All right, we'll be in recess for a little bit.
Do you have an idea on time, Your Honor, so we can be back here?
I'm gonna shoot for a half an hour. Thank you all for your patience.
Thank you, Judge.
Back on the record, if I could take appearances of counsel just for the purpose of the record again.
Your Honor, Daniel Simpkins on behalf of the state of Florida.
Jeanette Castillo with the Public Defender's Office.
All right. And we're here on Matthew Thompson. Is that you, sir?
Yes, sir.
All right, Mr. Thompson, we are here for a first appearance on charges relating to battery by strangulation and battery misdemeanor 1.
Your Honor, he's asking for the PD to be appointed on his case. We have a concern for PC on strangulation charge.
Okay, court appoints the public defender to represent you, Mr. Thompson. If you can go ahead and give argument as to the PC.
So the police report mentions that the victim doesn't remember if she lost consciousness or not. It looks like both defendant and victim were intoxicated during the entire incident, allegedly. We find that if she cannot confirm or deny that she was ever strangulated, then the battery charge that he's already got on count 2 would suffice. This is something that happened from the same incident. I don't see that there's PC for battery by strangulation.
Well, she can't remember having lost consciousness. That doesn't mean that that it doesn't properly allege being strangled, right?
We'd argue that for strangulation, she'd have to have thought that she was going to lose consciousness
Okay.
to some degree. If not, it's just a battery.
Okay.
And,
State.
Your Honor, the state would note the portion of the arrest affidavit which details the officer noticing the marks on not only the face, but the neck of the victim. This, combined with the fact that the victim could not remember whether or not she lost consciousness, indicates that she may in fact have briefly blacked out or have had a lapse in consciousness. Essentially, Your Honor, the fact that somebody can't remember for sure whether or not they lost consciousness might itself be an indication of battery by strangulation because they may have lost consciousness and thus not remembered losing consciousness. Incidentally, Judge, the mention of the marks on the face and neck of the victim is start of paragraph 4 in my copy.
Based on the four corners of the arrest affidavit, the court finds probable cause with respect to both the battery by strangulation as well as the battery count.
He does qualify for PTR, Your Honor. He's asking.
Any contact from the victim?
We were unable to contact the victim, and also when we were talking with him, they do share a residence, and he has no family in the area, so he has no alternative address. That would be an issue without the victim being here.
Your Honor, it looks like he does not have a previous history of any convictions, including any conviction for a DV battery charge. We'd ask that, he's actually asking that he be released on bond instead of PTR, and with that, no hostile contact could be ordered. It looks like their boyfriend and girlfriend, they do reside together, but nothing has ever happened before that would allow the court to think this would happen again.
And Your Honor, state would ask that whether the court sets a bond in recognition of the felonious nature of this domestic violence battery, or whether the court elects to place the defendant on pretrial release pending some sort of address update. Regardless of what the court does, the state requests that the court issue a no contact order and also mandate that the defendant not use alcohol or controlled substances during the time of release, because of the fact that it appears that heavy intoxication was a factor in the offense.
Looks like a substantial factor. The court will set bond in the amount of $500 with respect to the battery by strangulation charge, $150 with respect to the other battery charge, order no hostile contact, and no use of alcohol or controlled substances during the period of release. Anything further?
Nothing further, Your Honor.
Thank you very much.
Okay, this is yours. You're welcome.
Marco Abelos,
Yes,
case
sir.
number 2020 MM140. Here for a first appearance on charges of, or a single charge of battery, I should say. Do you wish for the public defender to represent you in this matter? I see that you qualify.
Yes, Your Honor.
All right, the court appoints the public defender. The court has reviewed the arrest affidavit and finds probable cause for the charge. Defendant does not qualify for a pretrial release. The event appears to have occurred at his sister's and mom's house. Is that right?
Yes.
All right, does anyone wish to be heard before the court sets bond and the conditions?
Yes, Your Honor. It looks like he also does not have any criminal history in or out of Florida. And although he does not qualify for PTR, it looks like he does have a low risk assessment. We ask that you set bond at $500 or less.
And Judge, this is defendant Marco Avalos, correct?
Correct.
All right, the state is showing 5 prior felony convictions,
I'm
6
sorry.
prior misdemeanor
Yeah.
convictions.
I looked at the wrong paper. I apologize. Sorry. Let me take this rubber band off.
The state would note for the court's consideration the fact that there are prior arrests for battery and for domestic violence. Considering that and the defendant's criminal history, the state would recommend that the court impose a bond substantially higher than $500, though the exact amount would be left in the court's discretion. The state would also be requesting that there be no contact with the victim and no return.
Your Honor, I'm sorry. Now that I am looking at the correct sheet, the risk assessment is still below average. And it is my understanding that any of the relevant convictions in his history are old. It doesn't appear that they have been within the last year, just driving while license suspended.
All right, the court will set bond on the battery charge in the amount of $500. Order no return to the mother and sister's house and no contact with the mother and sister. Anything further?
Nothing further, Your Honor.
No,
Thank you.
Judge.
Thank you, Your Honor.
Yep.
All right. Kim Hall, 2020 MM1236. Are you Ms. Hall?
Yes.
All right, Ms. Hall, we are here on a first appearance on a charge of battery domestic violence. You have the right to remain silent. Anything you say can be used against you. You have qualified for the PD to be appointed to represent you. Do you wish the PD to represent you here today?
Yes.
All right, the public defender will be appointed. Court's reviewed the arrest affidavit and finds probable cause for the charge alleged. State wish to be heard?
Your Honor, state would request that the judge set a bond for the defendant. The state would also request that the court impose the condition of no return and no contact.
Your Honor, she qualifies for PTR, also has a low risk assessment. Result doesn't look like she has any criminal history, and I am looking at the correct sheet. We ask that she be released on PTR.
Your Honor, she has no alternative address at this time, and the victim is not in court, so we would ask if you were going to order PTR, to please order bond or PTR if qualifies.
Your Honor, she can provide an alternative address upon release.
What was the nature of the victim contact?
The victim was contacted, Your Honor, and the only note that I have is that he will not attend court.
Right, the court will set bond in the amount of $500 and order no hostile contact.
And, Your Honor, the court is not going to impose a condition of no return?
I am not. It appears they reside together, and it appears that alcohol was potentially, is that mentioned in the arrest affidavit? I thought it was.
Yes, Your Honor, I remember reading that.
All right, direct no controlled substances or alcohol during the period of release. Thank you. All right, Jesse Merchant, case number 2020 MM1224. Mr. Merchant, you're here for a first appearance on a charge of battery domestic violence. You have the right to remain silent. Anything you say may be used against you. You have qualified for appointment of the public defender. Do you wish to have the public defender appointed?
Yes.
All right, public defender will be appointed to represent Mr. Merchant. The court has reviewed the charging affidavit, and I'm familiar with the case from Mr. Merchant's stepson in juvenile this morning.
He does qualify for PTR, Your Honor.
Okay.
And Judge, the state is also familiar with the case from this morning. To the state's recollection, now that I'm thinking about it, I believe in this particular case, the stepson is now residing elsewhere, or?
That's right.
Okay, so as a result, Judge, because they would not be cohabitating, the state would request that any release also contain the conditions of no contact with the stepson and no return to the location where the stepson currently resides.
Right. So, any defense have any issue with any of that?
Your Honor, since the juvenile does not reside at the same location and we are going to order no contact, we ask that he be released on ROR instead. I don't see that he's got any history. It looks like he does qualify for the PTR, so there's a low-risk assessment, and it doesn't look like there's any reason for us to believe he couldn't come back to court responsibly.
Okay. State?
PTR would provide an extra enforcement mechanism for the conditions imposed by the court. Besides that, the state is in a position.
All right. Court will order pretrial release with the conditions of no return, no contact. I'm trying to contemplate if Jason comes to visit his mother, that no contact would apply there if he comes there to visit his mother. I don't want Mr. Merchant's presence to impair his ability to see his mother.
Your Honor. Also, pretrial, we would have to verify the address of where the child was going in order for him to go back to that residence, because with pretrial, what we're trying to do is, I know in open court that was done, but they're not going to know downstairs when it passes paperwork on that child's no longer there. So, and if they can't get a hold of anyone, so I was just trying to stave off any
All right.
being here. and
So
not-
similar to the previous case, 500,
Similar,
all right.
yes.
The court will set bond in the amount of $500 or pretrial release if he qualifies based on the affidavits and no contact with Jason Okendo. Anything further?
Nothing further, Your Honor.
All right, thank you. All right, David Jerome Pickett, 2020 MM1233. Is that you, Mr. Pickett?
Hey, how you doing, sir?
How are you? You're here for a first appearance on a charge of domestic violence battery. You have the right to remain silent. Anything you say may be used against you. I have reviewed an application for indigency, and it appears you do not qualify for the appointment of the public defender. The court has reviewed the arrest affidavit and finds probable cause for the charge alleged. What says the state with respect to bond?
Your Honor, with regards to the court's decision, the state would direct the court not only to review the egregious language that was used by the defendant in this case, but also the fact that his most recent arrest was in North Carolina in October 2019 for habitual misdemeanor assault. He has an extensive history of victim crimes, including assault on female, assault with a deadly weapon, and the possession of stolen firearms. There's also assault by strangulation in his history. Considering the defendant's history, the state requests that the court consider the possibility of keeping the defendant no bond. If bond is instituted, state requests no contact, no return to the scene of the crime, and
Scene of the
any
crime
other.
was the airport, right?
I believe so, Judge. And
Yes, sir.
I believe that the victim also lives out of state, so that may assist in making sure that if she returns for trial or to provide other testimony, that would remove at least one avenue by which she could be interrupted. But of course, this is more attenuated in terms of location than most battery DVs.
Mr. Pickett, anything you want the court to know?
Yes, sir. That I stay in North Carolina. I was just on a vacation from the Bahamas. Me and my girlfriend got into a little altercation, and I did not want to talk to the police and tell them my side of the story. And everything that's on the paperwork that y'all see is all from her. And I'm gonna tell you right now, sir, that that's not true. I mean, I know I have problems. I have court in October, and I have to be at work tomorrow. I missed my flight and everything, sir. I do not stay around. This is my first time in Orlando. Me and her went to a cruise to the Bahamas. And on our way back home to North Carolina, this is when all this occurred, sir. We stayed in the Bahamas for 5 days, sir.
Right. Understood.
I have no way home. I have court in North Carolina and a job, sir.
All right.
State would also note the importance of all of these procedures in ensuring defense's attendance to court proceedings, which would be somewhat attenuated if he were several states away.
Given the defendant's residence out of state, the court takes that into account in setting bond in the amount of $2,500 and will condition bond on no contact with the defendant. Question as to the enforceability of that outside this jurisdiction, but it will be no contact for as long as...
No contact with the victim, Judge?
No contact with the victim. What did I say?
Defendant, Judge.
Oh, no contact with the victim. All right, thank you. All right, we are here in the matter of Sherry Prasad Rikharam, 2020 MM1235. Ms. Rikharam, You are here on an initial appearance on a charge of battery domestic violence. You have the right to remain silent. Anything you say may be used against you. You also have the right to an attorney, and I see that you have qualified for appointment of the public defender to represent you. Do you wish for the public defender to represent you?
Yes.
Okay. Public defender is appointed on behalf of Ms. Rick Moran.
She qualifies for PTR, Your Honor.
State sees that there's also not an alternative address provided at the time.
Yes, the victim and the defendant share the same residence, and no alternative address was provided. The contact with, victim contact made and says will attend court, but they're not here.
So the victim said they would attend? He
They
would-
said they would attend, but they're not here, so they would be at yours.
Your Honor, we'd ask that you order no hostile contact. It looks like she doesn't have a history, and she does have a low-risk assessment result.
Right, court sets, well, I'm not sure if I found, for the record, if I didn't, probable cause has been found. The court will set bond in the amount of $500 and order no hostile contact.
She does qualify for PTR, so is that an option? Judge?
Without an alternative address, Judge, the state would likely recommend a bond
Well, I
instead.
mean, why do we need an alternative address?
Well, with them not being here, we would be putting the defendant and victim back at the same residence from PTR. PTR won't do that. If you say no hostile, they would do it, but if we called, and what if they said they didn't want it back there? We don't know without talking to the victim if they want contact with them or not, so.
Okay.
Then that wasn't discussed, and we wouldn't ask,
Your Honor,
we wouldn't ask them on the phone, Your Honor. That's why we don't do that.
Right.
you did say no hostile.
I said no hostile contact.
Okay, and then I just want to bring to your attention, she works for Universal and has worked there for 15 years, so I don't think she's going anywhere.
All right. So I guess for the time being, then I'll order $500 bond or PTR if the alternative address is provided and the victim manifests consent to their being in the same
If
residence.
they say, sure, they can come, we could put it for that same address, but just to say,
Okay.
I guess they could handle that on their own, but would.
Okay. 500 bond or PTR upon provision of the appropriate alternative address, no hostile contact in any event. Anything further?
Nothing further.
No,
Your Honor.
Judge.
All right, thank you. Right, Robert Lee Weber, 2020 MM 1249. Mr. Weber, you are here for an initial appearance on a charge of stalking domestic violence. You have the right to remain silent. Anything you say may be used against you. You have the right to an attorney, and you have qualified for appointment of the public defender on your behalf. Would you like the court to appoint the public defender?
Sir.
Right, Public
Yes,
defender.
sir.
Public defender is appointed. Court finds probable cause with respect to the charge. What says the state with respect to bond?
Your Honor, the state is concerned by the statements allegedly made by the defendant and attested to in the sworn arrest affidavit. Considering the particular situation, the state would request a fairly high bond in order to better compel the defendant to observe the conditions of his release, the conditions being no contact with the victim, no return to her home, no return to the scene. If that is different, I don't know what the exact location is. And the state also notes that some of the stalking is apparently through Instagram, a social media site. State would also request that the court order that the defendant not use Instagram during the period of his pending trial.
Defense would object to the no use of Instagram.
will set bond at $500. Conditions, no contact with Gabrielle Gifford, or am I getting the last name right?
Gabrielle Gifford, Judge.
Gabrielle Rose Gifford, including electronic communication, specifically including the use of Instagram in order to contact Ms. Gifford. Anything further?
Nothing further, Your Honor.
The state would just request that the court add the condition of no return to the residence of the victim.
No return to the residence of the victim.
Not till this is
Right. Montravius Alston, 2020 CF 2099. You are here, Mr. Alston, on an initial appearance on charges of possession of fentanyl, burglary of a structure, trespass in dwelling, criminal mischief, and possession of drug paraphernalia. You have the right to remain silent. Anything you say could be used against you. You also have the right to an attorney, and it appears you have qualified for appointment of the public defender. Do you wish the public defender to represent you in this matter?
Yes.
All right, public defender is appointed. Court has reviewed the arrest affidavit and finds probable cause for each of the charges alleged. I understand we have dealt with a number of defendants from this group today. I think these were all the folks that were in an abandoned apartment, is that, or vacant apartment?
I believe that is the case, Judge.
Okay.
With this particular defendant, Judge, the state would be requesting that he be held without bond. The main motivation for that fact is the fact that it's been less than 6 months since the defendant was convicted of burglary of a dwelling, felony criminal mischief, resisting an officer without violence, petty theft, and possession of cocaine. It appears to not have had an impact on the defendant to have been convicted of those offenses, and as a result, for the safety of the community, the state would be requesting no bond. If the judge does elect to issue a bond, the state would be requesting that it be in a high enough amount to ensure that the defendant does not perpetrate any further offenses. And further, the state would be requesting a condition of release, if release is granted, to be random urinalysis and no consumption of alcohol or drugs.
Your Honor, if he's not being charged with a capital offense or a punishable by life offense, he's entitled to bond, considering, looking at the other factors. He was given a bond on the police reports for these charges, so we'd ask that you at least stick to those numbers. Looks like it was possession of fentanyl was $1,000, burglary of a structure was $3,500, trespass in dwelling was $500, criminal mischief $500, possession of drug paraphernalia $500, and possession of meth is $1,000. These are allegations. There were multiple co-defendants, and with that being said, it's not justified that he stay without bond.
Right. Thank you. The court will grant bond as to the possession of fentanyl charge in the amount of $1,000, as to the burglary of structure in the amount of $3,500, and as to the trespass, criminal mischief, and possession of drug paraphernalia charges, $150 each. As a further condition, court will order random urinalysis during the period of release. $150. Anything further?
Nothing further, Your Honor.
All right,
No,
thank you. All right, Nathan Baker, 2020 CF 2095. Mr. Baker, you are here for an initial appearance on a charge of possession of methamphetamine. You have title to an attorney, and if you can't afford one, the public defender can be appointed to represent you in this matter. Do you want the public defender to represent you? Do you have the ability to retain your own counsel? No? Okay, the public defender is appointed. Court finds probable cause for the charge alleged in the arrest affidavit. Does the state wish to be heard as to bond?
Your Honor, the state would recommend pretrial release for this defendant, with the added condition that the defendant not use or possess any controlled substances during the time of release.
What says the defense?
No objection, Your Honor.
Court will order pretrial release for Mr. Baker with a condition of no use of controlled substances. Thank you. All right, Michael Bassler, 2020 CF 2089. You're here for an initial appearance on a charge of grand theft in the third degree. You have qualified for appointment of the public defender, so unless you tell me otherwise, the court will appoint the public defender to represent you in this matter. What says the state is to bond?
Your Honor, the state will request a particularly high bond. This defendant has a high risk assessment result, does not qualify for PTR, has an extensive rap sheet including a number of different theft offenses for which the defendant was convicted. He also has crimes not only within the state of Florida but out-of-state convictions as well, including other arrests that may or may not have resulted in convictions. There's no indication of those. As a result of the defendant's extensive history and the fact that he has not, as it were, changed his ways, the state is recommending a particularly high bond and no return to the scene of the crime.
Your Honor, he is alleged to have committed this offense before the offense that he was already at the jail for. So we ask that at the very minimum, we stay with the bond that's already on the police report of $1,000 for the grand theft.
Court sets the bond at $1,000 and will order no return to the scene. Anything further?
Nothing further, Your Honor.
Thank you. All right. Alberto Omar Branda Rivera, 2020 CF 560. You're here on an initial appearance on charges of conspiracy to commit retail theft and petty theft. You have qualified for appointment of the public defender, and this is an extradition. Unless you tell me otherwise, I'll appoint the public defender to represent you. Is that what you want? All right, the public defender is appointed. Court finds probable cause with respect to the underlying claims, but it appears Mr. Branda Rivera was ROR'd on previous charges of possession of cocaine, heroin, and drug paraphernalia and driving on a suspended license. State?
Your Honor, state would request that with regards to these two offenses, the conspiracy to commit retail theft and the petty theft, the court used its own discretion in setting a bond amount. However, the state would request, since he was already out on release from prior offenses, that his ROR be revoked for those offenses. That would permit the trial court judge to see him once again and to reevaluate how exactly he would like to approach preparing the court in defense for trial.
Your Honor, defense would be asking that if you do revoke ROR, you set bond on the case he was already out on. And as to the current case, it looks like he had already been given a $1,500 bond on the conspiracy and a $1,000 on the petty theft. We ask that we lower those to $500 but on each count.
All right, the court will revoke defendant's pretrial release as to the original offenses, set bond, and the subsequent offenses as to conspiracy to commit retail theft in the amount of $500 and petty theft with a prior theft conviction in the amount of $500. Thank you. All right. Are you Taryn Burks? Reset. Christopher East? Christian Hernandez?
Yes, Your Honor.
All right. This is 2020 CF 2083. Mr. Hernandez, you're here for an initial appearance on a charge of possession of fentanyl. Appears you've qualified for representation by the public defender, so unless you tell me otherwise, the court will appoint the public defender to represent you. Court finds probable cause for the charge alleged. What's the state say as to bond?
State requests that the court leave the bond as is.
Your Honor, defense is asking that you lower the bond to 500.
I'm sorry, I didn't hear that.
That you lower the bond to 500.
Court sets bond in the amount of $1,000 as to the charge for possession of fentanyl. Anything further?
Nothing further, Your Honor.
Rodriguez Jules? Is that you, sir?
Yes, sir.
All right, you are here on a first appearance related to charges of burglary of a dwelling or motor vehicle. Two counts of grand theft in the third degree, a count of criminal mischief, and a count of resisting officer without violence. You have qualified for appointment of the public defender to represent you, so the court will do that unless you tell me you don't want the public defender to represent you. Court finds probable cause with respect to the charges alleged. Parties like to be heard as to bond.
State recommends leaving the bond as is.
Your Honor, we ask that the burglary of the dwelling with motor vehicle be reduced to $2,000 each. And that the others remain as is. And that you take no action on the existing. Also, I'm sorry, Your Honor, as to the resisting without violence PC, the police report doesn't, if I remember correctly, didn't even allege that they were arrested on that. In the facts of the police report for the alleged offenses, all it states is that the defendant and his co-defendant allegedly were fleeing. It doesn't say that the officers had at any point asked them to stop. It doesn't look like the sirens were alleged to have been on, nor that the lights were on. If we honor the plain reading of the police report, it looks like they could have actually just been running, not necessarily from the police. So we ask that you find no probable cause as to that count.
And state's response is that the individuals in question were fleeing from the stopped vehicle when the police were on scene. The state would say that there is probable cause here. If the court finds otherwise, the state would request 24 hours in order to get probable cause.
Court finds probable cause as to that claim as well. Takes no action on the bond with respect to the previous charges, and will set bond as to the burglary count in the amount of $5,000, the other burglary count in the amount of $250, the grand theft third degree $250, grand theft third degree $250, criminal mischief $150, resisting officer without violence $150. Anything further?
Nothing further, Your Honor.
Thank you. All right, Veronica Lopez, 2020 CF 2079. Ms. Lopez, you are here for an initial appearance related to a charge of grand theft and dealing in stolen property. Have let's see here. You have qualified for appointment for the public defender to represent you in this matter. Would you like the public defender to represent you? The public defender will be appointed. Court finds probable cause with respect to the charges alleged. Does any party wish to be heard as to bond?
Yes, Your Honor. As to the dealing in stolen property, we ask that it be reduced to $1,000.
And Your Honor, for the state, I'm seeing from the face sheet that there is an open warrant for the defendant in Arizona for failure to appear. The state would ask the court to consider holding the defendant until Arizona can have their voice heard in terms of possible extradition. Besides that, with regards to the actual bond amounts, the state would request that the court leave the bond as is.
Your Honor, if we could look into that Arizona warrant, it looks like that might be an error. I don't want you to say anything on it.
I'm not going to hold her on no bond until there's greater certainty.
Understandable, Judge.
So the court will set bond as to the dealing in stolen property charge in the amount of $2,500 and the grand theft bond in the amount of $150. Ah, yes, it did.
State would also request no return.
That's 2,500 as did both.
Sorry, Your Honor, can we clarify 2,500 as to?
25 as do both of the charges of dealing in stolen property. I'm sorry, that's still not clear, is it? The total amount for both charges is $2,500.
Okay, so the 150 is,
Count one in the grand theft.
okay.
And no return,
So her total bond for all the charges is 2,650?
correct.
Okay,
I'm,
that's what I'm trying to confirm.
it's 2,650.
She has three charges. She has count one, and then she has two dealing in stolen property.
So can she be ROR'd on the third one or something, just for record purposes? Judge?
ROR'd on what?
It looks like there's confusion as to the 2,500 on the both dealing in stolen property. So just for purposes of paperwork, can we put ROR on count 3? It's included in the 25 as what you're,
Or 1,250 as to each?
okay. That works.
1250 as to
Each of the two dealing in stolen property claims,
All right,
charges.
thank you.
As to no return, this was a duplex, wasn't it?
I believe there were multiple units involved.
But she resided in one of them, right?
Yes. I mean, no contact with the victim, if anything, because it's possible they might run into each other in the hall.
Yeah, no intentional contact with the victim and no entry into the residence.
Your Honor,
Yes?
also on the warrant, there's no extradition, it's interstate pickup only.
Okay. All right, anything further?
No, Judge.
Thank you.
Nothing further, Your Honor. Thank you.
Nicholas Luisis bonded out, yes? Gregory McGriff?
Yes, sir.
All right, Gregory McGriff, 2020 CF 2102, here on a first appearance related to charges of possession of a concealed weapon by a convicted felon, possession of ammunition by a convicted felon, possession of cocaine, grand theft in the third degree with a firearm, and possession of cannabis less than 20 grams. You do not qualify for appointment of the public defender. Public defender will not be appointed. So just recall that anything you say may be used against you. You have the right to remain silent. Court finds probable cause as to each of the charges alleged. Does the state have any input as to bond?
State would recommend that the court just keep the bond as is.
Is there anything you would like the court to know, Mr. McGriff?
I never saw probable cause for me to be pulled over. My license and everything was straight, and like I said, I didn't see probable cause, but I was just gonna ask if my bond could be lowered, or if I qualify for R&R.
Mr. McGriff has challenged cause as to the initial stop.
And, Your Honor, I don't believe that the defendant is actually charged with an offense from the initial stop. Everything was subsequent to that. So that would be the appropriate form for a motion to suppress. Yes, Judge.
Court finds probable cause as to each of the claims. Will set bond on the possession of a concealed weapon by a convicted felon in the amount of $4,000, possession of ammunition by a convicted felon in the amount of $150, and $150 as to each of the remaining charges. Thank you very much. Mr. Milton has bonded out.
Yes, sir.
All right, Christelle Murthel, 2020 CF 2100. Ms. Murthel, you're here for a first appearance related to charges of possession of fentanyl, burglary to an unoccupied structure, possession of drug paraphernalia, trespass, and criminal mischief. I don't see whether or not you've qualified for appointment of the public defender. Do you have can you afford to hire a private lawyer to represent you? Do you wish for the public defender to represent you? The court will appoint the public defender.
Your Honor, it looks like she qualifies for PTR. Pretrial release. It lets you go. If he allows it.
She does meet their criteria, Your Honor. I can read you her history if it's not on the paperwork that you have. She has no history.
I'm seeing she doesn't qualify for PTR.
Yes, Your Honor, on that, she wasn't interviewed, so she was interviewed later in the day today. She doesn't have any history, and they verified all of her community ties, so she does meet the criteria for pretrial if you choose to give that to her.
What says the state?
Your Honor, in lieu of pretrial release, the state would recommend the bond be kept. However, the state would also recommend a lowering of the bond on possession of drug paraphernalia to an appropriate amount.
With the information provided, Your Honor, it looks like she doesn't have any history, and she qualifies for PTR for a reason. We'd ask that you adhere to that. Her risk assessment result is below average. There's no reason for why she wouldn't appear to her next court dates pending resolution of this case.
Right. I mean, I was considering the treatment of the other defendants, but I guess it's more appropriate to look at her particular.
I don't think all the
History.
co-defendants qualify for PTR, so she's
Right.
special.
All right. Court will grant pretrial release as to Ms. Murthel.
The state would recommend that the court simply include a condition that the defendant not use or possess any controlled substances.
No use or possession of controlled substances during the period of release. Thank you.
Thank you.
Nieves Diaz has bonded out.
Yes, sir.
All right, Christine Sassano. Case number 2020 CF 2084. You are here for a first appearance on a charge of possession of fentanyl. Ms. Sassano, I see here you've qualified for appointment of the public defender, and the court will appoint the public defender to represent you. Court finds probable cause as to the, do you have a probable cause challenge?
No, sorry, she qualifies for PTR.
Oh, she does? Court finds probable cause. Defense? I'm sorry, state?
No objection to PTR, Judge. State would just request that the court also impose the condition of no use or possession of controlled substances.
So this is another one where subsequent to the initial report, she was interviewed and then qualified?
Yes, Your Honor. They were backed up this morning, so earlier in the day it was printed, but I do have it, and she has no history, and I can recite that.
No, all right, great. Court will grant pretrial release and include as a condition, no use or possession of controlled substances. Anything further?
Nothing further, Your Honor.
Thank you. All right, Chad Swain, 2020 CF 2098.
Your Honor, we're on Smith.
Smith?
Yes. Marl Smith.
I don't know what happened. Is there a Chad Swain? All right, sir, thank you. What? Oh, no. This is Morrill Smith. 2020 CF 2070. Mr. Smith, you are here on a first appearance on a charge of driving with a suspended license with 2 prior convictions for same, as well as you were out on ROR for trafficking 4 grams or more of heroin, possession of heroin. Do you have the ability to hire an attorney to represent you in this matter?
No, I just rather deal with the PD right now.
All right, court will appoint the public defender to represent you. Court finds probable cause for the charge alleged.
Your Honor, due to the nature of the new offense, we ask that you take no action on the existing offense. Looks like they're not related at all. The new offense is a duelist, and that we set bond at an amount lower than the $2,500.
And, Your Honor, on the new offense, the state would recommend that the court use its own discretion in setting a bond amount. However, with regards to the fact that the defendant was already released by the court system on a different case and still violated the terms of that release by committing a new crime, the state would request that this honorable court revoke his release in that case.
He was ROR'd on trafficking and heroin?
I thought I had heard Your Honor say that.
That's what I'm looking at.
It could have been a 33-day motion, Your Honor.
Yes.
All right, the court will take no action on the underlying charges. We'll set bond with respect to the driving with a suspended license charge in the amount of $2,500. Anything further?
No, Judge.
All right, thank you.
Your Honor, it looks like he does have court on the new case, or the old case. He just wants me to bring to your attention that he wants to be transported, if anything, for that date, the 18th.
Do I need to enter a transport order?
I don't think so, but
They told
he's
me
asking me to
to.
let you know, so I'm letting you know.
All right, you'll have every faith that you'll get there. All right, Chad Swain, 2020 CF 2098. Mr. Swain, you are here on a charge of possession of cocaine. Are you requesting the public defender to appoint you in this matter?
No, sir.
No? You do not have private counsel here today. So just recall, you were told, and I'll tell you again, that you have the right to remain silent. Anything you say may be used against you. Court finds probable cause for the charge alleged. What says the state with respect to bond?
Your Honor, the state does request a bond be issued, but would personally recommend that the court decrease the amount from $2,500 to perhaps $1,500.
Did you say 15?
Yes, Judge.
Court will grant that request, set bond in the amount of $1,500. Anything further?
State would also request that the defendant be ordered not to possess or use any controlled substances.
So ordered. Condition of the bond is not to use or possess controlled substances. Thank you, sir. All right, Terrence Tyrion Taylor, 2020 CF 2077. Mr. Taylor, you're here for an initial appearance on a charge of possession of cocaine with intent to sell or deliver with a firearm, carrying a concealed firearm, possession of drug paraphernalia. You see here, you do not qualify for appointment of the public defender. Court has found on a review of the arrest affidavit, probable cause for each of the charges alleged. Does the state wish to be heard as to bond?
Yes, Your Honor. Frankly, looking at the defendant's history, which also carries a charge of carrying a concealed firearm, and what apparently was an admission by the inmate to the personnel here of a drug history, that combined with the fact that the defendant was carrying a concealed firearm while being charged with possession of cocaine with an intent to sell or deliver, the state finds it a serious enough offense that the state would request the court either keep the bond as is or increase it.
All right, Mr. Taylor, is there anything you want the court to know?
No, right now.
All right. Court will set bond as to the possession of cocaine with intent to sell or deliver with a firearm in the amount of $5,000. Set bond as to carrying a concealed firearm in the amount of $500. And set bond in the amount of $500 as to the possession of drug paraphernalia charge.
So what's my bond total and all?
$3,500.
Uh,
No, I'm sorry, that's not right.
That'd be 6,000, Judge.
6,000, thank you.
All right, thank you.
Take care. All right. Carlson Toussaint?
Hi.
Hi. 2019 CF 13093. You are here on a first appearance related to a failure to appear on an underlying battery domestic violence charge. Qualify for appointment of the public defender. The court will appoint the public defender to represent you. State wish to be heard?
Yes, Your Honor. I believe Your Honor stated it was a failure to appear. That, of course, per the state's prior arguments, means that the bond should be left at whatever it is right now, pending the trial court having the opportunity to consult with the defendant.
Does the defense wish to be heard?
Just that you set bond, Your Honor, if one's not already set.
I'm sorry?
Just that you set bond if one was not already set on that FTA warrant.
All right, on the failure to appear, no bond until there's further proceedings in the underlying case. Thank you.
Your Honor, I'm sorry, just to clarify, what was the bond on the other ones, if any? I missed that.
No bond.
Okay. That's a trial issue, it's not for today. Yes, but it had 3 counts, correct?
It was just FTA,
Okay. Oh, okay, that's what it was then. All right. Thank you.
All right. Janie Valentine, 2020 CF 2093. Ma'am, you are here on a first appearance on charges of possession of cocaine and possession of drug paraphernalia. You qualify for appointment of the public defender, so the court will appoint the public defender to represent you. Court finds probable cause with respect to the charges alleged. And what says the state with respect to bond?
Your Honor, state merely requests that the court keep bond as it is.
Your Honor, it looks like she has kids at home and she's requesting she be released on ROR, at least in the alternative to maybe 500 on the cocaine and ROR on the paraphernalia count.
Court sets bond in the amount of $500 with respect to the possession of cocaine charge and $250 with respect to the possession of drug paraphernalia.
You're charged with 2 counts, so he lowered the bond.
Anything further?
Nothing further, Your Honor.
Thank you.
It's a total of these 2. I don't
Right. Sharik Williams, 2020 CF 2087. Mr. Williams, you're here on first appearance on a charge of possession of cocaine with a weapon and possession of cocaine with intent to sell or deliver. You qualify for appointment of the public defender, so the court will appoint the public defender to represent you. Court has found, based on the arrest affidavit, probable cause with respect to each of the charges. State wish to be heard with respect to bond.
Yes, Your Honor, state would request that the defendant be issued a reasonable but high bond, that the defendant be ordered to undergo random urinalysis, and that the defendant be required to surrender any and all firearms he possesses.
Defense?
Yes, Your Honor. We ask that bond be set on both counts and not order the random urine analysis or the surrendering of the weapon.
Court sets bond on the possession of cocaine with a weapon charge in the amount of $5,000. And as to the possession of cocaine with intent to sell and deliver in the amount of $1,500. No conditions. Thank you. All right, Anthony Wilson, 2020 CF 2101. You are here today on a first appearance with respect to charges of dealing in stolen property, driving with a suspended license, trespass on a conveyance, and possession of burglary tools. You qualify for appointment of the public defender, and the court will therefore appoint the public defender to represent you. In addition to these, it appears these charges occurred while out on bond on possession of cocaine, paraphernalia, and trespass charges. State?
Your Honor, state would recommend that the court keep the bond in these charges as it's currently set and revoke the defendant's previous release conditions. Basically, there's no guarantee that the defendant's behavior is insured by being out on bond. Perhaps that will inform the trial court of how best to proceed in the future.
Defense requests that you take no action on the two existing cases and keep bond as currently set on the new one.
The possession and trespass charges occurred after existing charges for trespass, grand theft, right? Those are two separate cases?
Two separate cases, yes.
Okay.
Looks like he was ROR'd on 33-day motion on the 3822 case and was out on bond on the 1657
Right.
4 case.
Court will set bond on the dealing in stolen property charge in the amount of $2,500, the driving with a suspended license in the amount of $250, and trespass, $100, possession of burglary tools, $150. And take no action as to the existing cases. Thank you. Right. Ghazi Badib, 2020 MM 1243.
Sorry, Your Honor, it looks like we're on Michael Florent. He is Michael Florent. He's the third one on misdemeanor pleables.
All right, Michael Florent, 2020 MM 1242. Mr. Florent, you are here on a first appearance related to charges for trespass in a structure and criminal mischief. You qualify for appointment of the public defender, and the court will appoint the public defender to represent you if you want. Yes?
Yes.
All right. Court's reviewed the arrest affidavit and finds probable cause for the charges alleged. What says the state is to bond?
Your Honor, state leaves bond in Your Honor's discretion.
Your Honor, defense would ask that you stay the trespass at 250 and the crim is set at 100.
Court sets bond on the trespass claim in the amount of $250 and criminal mischief in the amount of $100. Thank you. Who do you have next, ma'am?
What's your name? Harling. We've got Carrie Harling.
I'm sorry?
Carrie Harling. Where the items are.
All right, Carrie Elizabeth Harling, 2020 MM 1231. Here, Ms. Harling, on a first appearance on a charge of petty theft. You've qualified for appointment of the public defender. The court will accordingly appoint the public defender to represent you in this case. The court's reviewed the arrest affidavit and has found probable cause for the charge alleged.
Your Honor, defense is asking that the defendant be released on ROR. It looks like all of the items were recovered on the date of the arrest.
State?
State does request a bond, Judge.
State does request a bond?
Yes.
Court will set bond in the amount of $500 on the petty theft claim.
Your Honor, can we do 250?
Based on the recovery of the merchandise?
Yes.
All right, the court will reconsider and set bond at $250 in light of the contrition reflected in the arrest affidavit. Anything further?
Nothing further, Your Honor. Thank you.
Thank you.
Your Honor, I had Christina Duran in the line. Did that defendant bond out? I'm sorry?
Mental health.
Oh, mental health, thank you.
Ghazi Badib.
This is Sadia Marone.
Did you look at something, says she bonded? 2004-589. Kazi Badid. Huh? 204589. It's fine. Fine. Okay, thank you.
All right, Sadia Maroon?
Yes.
All right. 2020 MM1241, you're here, Ms. Marone, on a first appearance on charges of trespass and criminal mischief. You qualify for appointment of the public defender, and the court will appoint the public defender to represent you.
She qualifies for PTR.
She does. What says the state?
No objection to pretrial release with the condition that she not return to the location.
All right, court grants pretrial release conditioned on no return to the Caden Apartments. I believe that's the location, right?
It was an apartment complex.
Yes.
Yes.
All right, thank you.
Thank you.
Was Williamson Louis Jean mental health?
Yes, sir.
They probably already got notified that they may let you serve it here or go get you.
What was that on Louis Jean, Judge?
Mental health.
Mental health. Oh, thank you.
And are you Alicia Rivers?
Yes, I am.
All right, 2020 MM1234. Ms. Rivers, you are here for a first appearance on a charge of petty theft. You qualify for appointment of the public defender, and the court will appoint the public defender to represent you.
She qualifies for PTR, Your Honor. I know she has a Seminole County hold.
Your Honor, I think that the PTR, the out-of-county hold is for her to go serve a sentence for 150 days. So I don't think PTR would be appropriate for her.
Incidentally, Judge, state would concur.
I'm sorry?
State would concur with the assessment offered by the representative from PTR.
Defense would ask that she be held on PTR to this case, but she would still be serving a Seminole County hold, whatever the sentence is.
All right, court will grant pretrial release pending the hold.
Thank you, Your Honor. Or, the sheet I have in front of me says ROR was, PTR was okay. It's from PTR
Yeah,
services.
but looking at this, I don't know when this hold went in. It could have gone in after they screened her for PTR, but there's 150 days, so, 6 months she's gonna be, I don't know how that's gonna work with the PTR.
So when she gets released on the hold, she would be released on PTR as to this case. It's not the same case. If she would ROR, for example, then she'd serve the 150 days and then be released ROR, so it's the same
Right.
thing. It's just that it's PTR.
She has a blowout first assessment, so she would be a phone in. I guess we'll.
Okay,
We'll see.
we'll see. Thank you. Thank you, ma'am. Scott Allen McLaughlin.
It was PTR.
All right, Gail Wessel?
Yes, hi.
All right.
I would like to request PTR to never return to the location that I was trespassed from.
Okay, thank you. This is 2020 MM 1216. Do you wish for the public defender to represent you in this case?
I don't believe I need that.
Okay,
It's the first time. I've never been handcuffed or in jail before, and it wasn't my intention.
Doesn't meet the PTR criteria. We tried to establish our community ties to have a place where we could do the PTR paperwork. We didn't qualify her.
Okay, can I do ROR then, or,
well, maybe.
okay.
It was the failure to have a verifiable address.
The note says defendant doesn't qualify for PR due to being homeless and no emergency contact with on-call room. That's your own.
Okay, trespass at,
I can stay with my parents in Longwood, so I can have an address.
Your Honor, state would recommend that the court issue an order keeping the bond at $500 or pretrial release if the other address can be verified.
Yes, my mail goes to that address.
this is the same location where there had been a previous trespass?
I'm sorry?
Have you been trespassed from there before?
Yes, yes. And I came back, I should have called first, but my girlfriend flew in from Connecticut, and I was looking for her. So it's my fault, I should have called first. They said if you call, you're fine.
Okay. Well, ROR, Ms. Wessel, condition not to return
Yes,
during the period of release.
which would be 1 year, correct?
Well,
Or whatever they say.
yes.
Okay,
Whatever is determined subsequently in this case.
okay. Yeah, they said I could fly out as long as I call ahead
You can address that with the,
with them.
With the
Sure,
court.
That's what they told me yesterday.
okay, thank you very much.
So what does that mean then?
What's that?
What do I do now?
You're released, but the case is not over. So there'll be further proceedings to determine, yeah, once you're released, you'll get a court date to return, which will determine, I mean, the proceedings aren't over, but they're over for today.
So I can actually leave here today?
I don't know what the procedure is and how long that'll take, but yes, you're released.
I'm released. Thank you, sir. Have a great night.
Thank you.
Your Honor, it looks like we're on out-of-county cases. PD is not necessary for one of these. Can I be excused for a few moments? Thank you. You'll get a PD once you go back.
All right, are you Gregory Culbreth?
Yes, sir.
You look like you were about to ask a question.
Yes, I'm confused.
Okay. You're here on an out-of-county warrant related to a grand theft charge in Seminole County. What says the state?
Your Honor, state requests that the defendant be held in custody until he can be transported.
All right, by virtue of the out-of-county warrant, you're going to be held until the Seminole County Sheriff's Office has the opportunity to transport you to address the charges that are pending in that jurisdiction, okay?
Can I ask another question?
Sure.
I'm just wondering if there's any kind of factual basis like that I can find out what this has to do with. I understand the charge in the county that it is in, but I don't understand, like, who's the victim, like, I don't understand anything besides the county and the charge.
Well,
Or would I have to go to Seminole County?
when
to
you
find
go to
out?
Seminole County, that'll be the opportunity for you to find all that out and to have an attorney appointed to assist you in determining up from down if you're unsure as to the nature of the charges, all right?
Is there a date of when the charge occurred?
Within 48 hours, right? Oh, the charge?
When the charge occurred, yes, sir.
I'm sorry, I don't have that information.
All right, thank you.
All right, take care.
Thank you.
All right, Taylor Moran?
Yes, sir.
All right. You're here on an initial appearance related to an out-of-county warrant for failure to appear for a pretrial in Pensacola?
Yes, it was in Kissimmee, in
Yeah.
Osceola. It wasn't in Pensacola, it was in Osceola County for the Kissimmee address.
Oh, it's Osceola. It says Peciola, I thought it said Pensacola.
Oh, I'm sorry.
Okay, Osceola.
As well, sir, I turned in, I was physically ill that day. I was supposed to be in court. I turned in information into the court. I called and they said to fax into the clerk's office information. I have a hospital note that I faxed in and they have given to the judge over there and everything. I just didn't realize I still had a warrant, that's all.
All right. State?
Your Honor, with regards to all of these out-of-county warrants, the state will be requesting that defendants be held until they can be transported.
Okay. By virtue of the out-of-county warrant, you'll be held without bond until you're transported to Osceola County, where further proceedings can be conducted there. All right?
Do you know how long that'll be?
That'll be within 48 hours, right? 24? Okay. Jacoya Polk? She refused. Reset her? Oh, okay. I don't need more to do, you know? Will be held for transport? No, don't reset it. All right. As do Ms. Polk, who's refused. The court finds she's waived her initial appearance and she'll be held for transport to Seminole County. Raymond Quick?
Yes, sir.
All right, you are here on an out-of-county warrant related to underlying charges from Volusia County. There is no bond on those counts in Volusia County, so you'll be held for transport to Volusia County where those charges were filed
How long will that be?
within 72 hours. Ivan Villalona?
Yes, sir.
All right. 2019 CF 3268, you're here on an initial appearance related to a probation violation arising out of Manatee County on the underlying charges of petty theft. You'll be held on the violation of probation for transfer to Manatee County. All right?
Yes, sir. And do they have like a certain amount of days? I know you told me 7 days. So after 72, will I be released?
You'll be there for further proceedings.
Yes, sir.
All right.
That's the first appearance of detainer, Your Honor. That's for, that's the first appearance.
Right, court will take no action on that.
Thank you, Your Honor.
What is the first, what does that mean?
You're on bond.
Okay.
All right, Stephen West?
Yes, sir.
All right, 2018 CF 35205. You're here, an initial appearance on an out-of-county warrant related to larceny charges out of Brevard County. There is no bond on those charges in Brevard, so you'll be held for transport to Brevard County for further proceedings there. Thank you. What's your name, sir?
Michael Baker.
Casada recused yonder, and Wilson is mental health.
Who refused?
Casada, Marcus Casada, he recused, and Wilson is mental health. Is that the John Doe? We didn't have the John Doe on our list. That was the one from the hospital yesterday, but he wasn't on our list today. Well, we don't add up Casada, whatever that is. Huh?
Don't have anything related to that person. All right. Mr. Baker, here on 2018 CF 10397. You're here on an initial appearance related to a violation of probation on underlying battery charges in Orange County. That warrant is no bond, so you will be held without bond for further proceedings. I'll appoint the public defender to represent you. Did you have anything to add, defense?
Nothing further, Your Honor.
All right, thank you. Luis Berrigan?
Yes, sir.
All right, 2020 MM 138. All right, you're here on a arrest warrant related to violation of probation, and I think new charges of possession of drug paraphernalia, is that right?
Yes.
Okay. Court will appoint the public defender to represent you. And it's a violation of probation, and the arrest warrant provides for no bond, so you'll be held without bond until further proceedings in the underlying trial division.
Your Honor, we ask that the bond on the other counts be reduced. For the possession of drug paraphernalia, we ask that it be set at 100, and for the possession of firearm, 1,000, possession of ammunition set at 100.
State wish to be heard?
State leaves it in the court's discretion.
Court will set bond on the possession of drug paraphernalia charge in the amount of $100, possession of firearm by a convicted felon $500, and possession of ammunition by a convicted felon $100.
You're welcome.
Thank you.
Thank you. All right, DeMarcus Hill?
Yes, sir.
All right, 2017 CF 9504, here on an initial appearance related to a probation violation. You do not qualify for appointment of the public defender. State, this is a VOP, but I don't see anything supporting it. Is there anything?
Supporting it, Judge, in terms of what the underlying charge was, or?
Yeah, yes.
One moment, Your Honor. My affidavit
Yes.
says 2017 CF 9504, burglary, occupied conveyance, and robbery. Probation.
I see. All right. Here to the probation violation. Mr. Hill will be held pending further proceedings in the trial division.
Could you repeat that, Your Honor? I don't think he heard you.
Mr. Hill will be held without bond for further proceedings in the trial division with respect to his probation violation.
No bond on the violation of probation. You're gonna talk to your attorney.
Thank you.
Anything about your case?
All right, Christopher May?
Yes, Your Honor.
Okay, this is 2019 CF 4924. Mr. May, you're here on a violation of probation arising out of petty theft claims in Orange County. You qualify for appointment of the public defender, and the court will appoint the public defender to represent you. Court, well, you've got a violation of probation as to the underlying claim of petty theft. Violation of probation with respect to trafficking in stolen property. Is there a new charge?
No, Your Honor.
No. By virtue of the violation of probation, Mr. May, you'll be held without bond pending further proceedings in the trial division related to those underlying charges. Anything further? All right, thank you. All right, Christian Rosa? All right, 2019 CF 725. Here an initial appearance related to a violation of probation. Qualify for appointment of the public defender, so the court will appoint the public defender to represent you. And you'll be held without bond on the probation violation for further proceedings before the court in that division.
Your Honor, just to clarify, the affidavit that I'm looking at, the arrest affidavit says bond of $1,000 on the VOP. Is it actually no bond, and was that a scrivener's error?
Defense would request that we honor the police report at 1,000.
They did a bond correction and set it at 9.
All right, set it at none?
Yes.
All right, thank you.
Thank you. All right. Kenneth Miller?
Yes, yes, Your Honor.
Oh, right, 2000,
Would you like to resolve this today? Did you want to resolve this today?
2020-251.
Yes,
You're here for a first appearance on disorderly conduct. You qualify for appointment of the public defender. Would you like me to appoint the public defender to represent you?
yes, yes, Your Honor.
All right, PD will be appointed. What says the state?
Your Honor, presuming the defendant does not wish to resolve his crime today, the state would leave the matter of bond in Your Honor's discretion.
Your Honor, he would like to resolve this today if we could hear an offer.
Oh, I'm sorry, Judge. I don't know why it's, I think there might be some clarification needed. I believe this is one of those cases that's charged as disorderly conduct when it could fall into, for instance, the panhandling or something along those lines.
I'm sorry.
Oftentimes, disorderly conduct is charged as more of a generalized offense for more specific conduct. I'm unclear as to what taking something from an occupant of a gray Acura sedan means. I want to make sure that it didn't involve the use of any theft or anything like that, but it appears that it actually was essentially a panhandling charge. Is that the reading of the court as well? I just wanted to make sure that nobody's Marcy's Law rights are being violated.
Your Honor, based on that statement, it looks like there might not be PC for the charge at all if we can't even determine what the actual charge is. We ask that we find no probable cause as to the offense. It also looks like, based on the police report's plain reading, that might actually criminalize innocent behavior. For example, let's say I leave my purse in an Uber and I go back and get it. Technically, that falls under the same conduct as the police report is alleging.
Oh, Your Honor, the state would contend there's most certainly probable cause here because it is a crime to do exactly as the report says, to distribute any object to or receive any object from an occupant of any motor vehicle stopped on a public roadway in obedience to a traffic control light, signal light rather, stop sign, or any other traffic control devices, which would be wholly separate from, for instance, running back to an Uber to grab your purse, as they would presumably not be stopped at a stop sign or at a red light or something like that. The state just wanted to make sure that this wasn't an incident of a theft offense. Would the court like to resolve the contest of probable cause before the state provides an offer?
Yeah, the court finds probable cause based on the conduct, and it's consistent with the ordinance. So understanding that probable cause has been found, does the state have an offer?
Yes, Your Honor. It would be an adjudication, court costs, and credit for any time served.
Defense would ask for a withhold court costs and credit time served.
And the extensive enough criminal history of the defendant, including similar crimes, for instance, commercial use of state right-of-way, would indicate that an adjudication would be more appropriate.
Your client agree to adjudication?
If we were to plead to the bench, could we get a withhold?
Your Honor, I'm under the impression that at initial appearances, defendants actually cannot plead to the bench. The judge essentially acts to facilitate the resolution between the state and the defense. Of course, if this case were to result in, for instance, a bond or something instead, the defendant would be more than welcome to plead to the bench at whatever trial division he's assigned to.
How do you respond to that?
I'd like to see a statute number, Your Honor, if that's what Your Honor is. I'm not even sure what to say to that.
I think it's permissible to take a plea to the bench. Does your client wish to do so?